I had a division bench, so I'm little late.
Happy the Lordship.
Yes.
By the item number 17.
17.
17.
Yes.
These have newly engaged ones and I have like a file a reply, my lords.
Okay. 17, right?
17. From it
Huh.
is from-
Okay. Mr. D. Gogoi, learned counsel for the respondent,
No petitioner, my lord.
for the petitioner, submits that he wants some time to file his affidavit in reply. Prayer is as such allowed. Release this matter on
July, my lord.
July. Vacation started. Release this matter on 15th of July.
My lord. Authorized.
Yes,
Lordship.
Mr. Choria.
Lordship, I beg to mention item 6 of today's list.
6.
Yes.
Yes.
With the consent of the other side, Lordship, we are required to file an affidavit. It has gone for signatures, Lordship. So I'm seeking 1 week's accommodation. I have
Okay.
informed-
You're there for the petitioner?
I'm for a petitioner, my lord. Let
Ah.
it come on 15, my lord. 15th.
15th of June. Okay. Mr. A. Choliha, learned standing counsel for PNRE department.
Finance Department, Lordship.
Finance department, yes.
Right.
Finance department submits that he would like to file an affidavit in opposition in the instant case and has prayed for some time. Prayer is allowed. List this matter on 15th of June.
Lordship.
May I please?
Yes, Ms. Borua.
I beg to mention item number 32, Lordship.
32.
Kindly fix it from next week, Lordship.
32 next week. Mr. D. Decca appears for the petitioner.
One.
Okay. Okay. Mrs. S. Borua, learned CGC, submits that they require some time to go through the case, go through the present case and has prayed for some time. Prayer is allowed. List this matter on, when did you say? 10th. Next Wednesday?
Yes.
10th of June.
Obligation.
May I please?
Mm.
I'd like to mention item 47, my lord,
47.
47. The come on, my lord, 24th of June.
24th of July.
June.
Oh, June. So what did you say? 47?
Yes.
Mr. B. Forecaster, this is 25 matter, okay. And what about the years of those matters? 24, okay. 25. Mr. B. Forecaster, learned counsel appearing for the petitioners, prays for a week's time. Prays for some time. To do the matter. Prayer is allowed. List this matter on
24th.
24th of June. 24th of June.
My lord,
Yes,
I'm
Mr.
mentioning item number 30, my lord, with the consent of the petitioner side, my lord. My lord, we are filing an affidavit. We need 1 week time. We have received the instruction.
Hmm.
So, my lord, the senior council has, my lord, agreed upon a date 17th.
17th of June.
Yes, sir.
Okay. Mr. Dhar, R. Dhar, learned government advocate, or learned standing counsel for PWD, prays that some time may be granted in the instant case. Prayer is allowed. List this matter on 17th.
17th, my lord.
17th of this month of June.
May I please, your lordship? Lordship, item number 39, lordship.
Hmm.
This matter has already been heard by a coordinate bench, lordship.
Acha.
So lordship may raise the matter in appropriate bench so that, pending for orders only.
Acha. So, right, Mr. J. Kolita, learned counsel for the petitioner, submits that the matter has been heard at length by a coordinate bench of justice.
This is Robin Pukan, lordship.
Within bracket DDY, Justice Robin Foucan. As such, he prays that the matter may be heard by the said bench. May be finally heard. Be finally heard by the said bench. Prayer is allowed. List before the appropriate bench.
Yeah, with the consent of the other side, I beg to mention item number 34.
Mm.
Here also the state respondents have filed affidavit
Hmm.
and my reply is also ready. During the course of the day, I will file it. So let the matter come up after a week.
Mr. A. Decca, learned counsel for the petitioner, submits that he will file his affidavit in reply within a day or two and has prayed for some time. Prayer is allowed. List this matter on
After a week, any date.
list this matter on 22nd of June.
Yes. Obliged.
Yes, Mr.
Lordship, with the consent of the others, I'd like to mention item number 15, Lordship.
15.
15.
Hmm.
My senior NK Chaudhary is having some medical difficulties, Lordship.
Acha. Okay.
Lordship,
Mr.
kindly fix it on 10th or 11th of June, Lordship.
10th or 11th of June. Okay. Mr.
R.
R. Gogoi, learned counsel for
Gohai,
the,
Lordship. R. Gohai.
R. Gohai, learned counsel for the petitioner, submits that the Conducting counsel has some medical issues and has prayed for some time. Prayer is allowed. List this matter on 11th of June.
May it please your ladyship. Ladyship, this is with regard to item number 35. We have
Mm.
filed our reply yesterday, lordship.
Mm.
There is a little urgency in this matter, so the records may be called, lordship.
Acha, you give the requisition then.
Deeply obliged.
Mm.
Yes, sir, Your Lordship. I'd like to mention item number 19, as my senior is out of station, they are.
Item number
19.
19. 19. Okay. Your senior is out of station. Okay, Miss
Case in RP.
Case in RP, learned counsel for the petitioner submits that the conducting counsel has some personal difficulty in doing the matter today. Prayer is allowed. List this matter on,
Next Monday.
list this matter on 15th of June. Okay. Mm.
Where this case is listed for the disposal, my lord.
Yes. Affidavits are filed, I guess. There are so many of them.
Affidavit is on record, my lord.
Hmm?
Thereafter, my learned friend has filed affidavit in reply and one additional affidavit also, my lord.
So pleadings are complete.
It is complete, my lord. My lord,
What happened?
only one my submission, my lord. I'm seeking little accommodation today, my lord. I have spoke to my brother in the morning. He wants to argue, my lord. Let him argue today, my lord. And I may be allowed to argue tomorrow or Monday, my lord. Any day. Because,
Hey, again, I'll forget. Why not today?
my lord,
Not a very big
what
matter.
happened, my lord? This file was could not be traced out in yesterday in the office, my lord. I have received the file today morning only, my lord. I need some time to prepare, my lord.
Okay, we will take it at one go. Tomorrow
2 o'clock.
Hmm?
No, yes, tomorrow.
or day after. Friday.
Friday, my lord.
Friday.
Friday.
Okay, we will hear it at one go. Small matter again. Piecemeal will be difficult for me to
In
dictate
this
again.
case, my lord, first somebody was appearing. Last time. So
No,
we
last
was
time- last
appearing.
time-
No, Mr. Das will appear.
I'll
Mr.
get-
Das, right?
No further adjournment will be. given.
Last time, my lord, Mr. A.R. Builder, he appeared, my lord.
Other
Acha.
than that, I may be,
But,
my lord, I am ready.
I'll do the hearing.
Ah, you are ready, but then again, I'll forget your arguments. You will have to repeat. There will be a time loss. So let it be at one go. We will hear it day after tomorrow.
My lord. After tomorrow.
Yeah, for tomorrow.
Day after tomorrow. Mr. Das, right?
My lord, my lord.
Mr. What Das?
Yes, that's my lord.
As Das, learned standing counsel
Higher
for
education, higher education.
higher education, prays for little accommodation, and request the matter to be taken up on
Friday.
taken up day after tomorrow. That is 5th of June. Prayer is allowed. List this matter accordingly. 5th of June.
The last adjournment, my lord, the
Okay, no, I'll remember. I'll not give any further.
Yeah, my lord, by last order, my lord, today fixed for final disposal. my
Uh-huh.
lord. Nobody was-
No further adjournment would be granted on Friday. Yes.
Lordship here, although the affidavit has already been filed, but there is a direction to file an additional affidavit
Mm.
to, uh, to clarify the reason as to why the service.
Director, secretary was directed to file an affidavit invariably disclosed why the name of petitioner was not recommended. And he requests further time to file the affidavit. As the last opportunity it was given.
Already that affidavit, additional affidavit has been sent for vetting, Lordship. Lordship will fix immediately next week, Lordship. In the meantime, we will ensure that we will file the affidavit. Already sent for vetting.
Mr. U. Sharma, learned
P
counsel.
N Sharma, Lordship.
P. N. Sharma, learned standing counsel for
Elementary.
elementary education submits that although the affidavit was supposed to be filed today, as per the court's order, the same has been sent for vetting
Lordship.
and will be filed as soon, will be filed within this week. And a prayer is made to take up this instant matter next week.
Yes.
Prayer is allowed. List this matter on
11th
16th, huh?
11th June,
11th of or 9th, 8th,
11/9.
9th of June. Okay?
Lordship.
9th of June.
Lordship. Abdul.
Obliged.
No further adjournment would be given. On failure to file the affidavit, the court will proceed with the pleadings as present in the said petition.
21 matter also.
Yes, 21 matters, see?
Lordship.
Item number one, my lord. This matter may be taken up at two on Friday, my lord.
Okay, up to লিখে দিবা।
Oblige.
Lordship, here in this matter, I have received my complete instruction. I need 10 days time to file an additional affidavit to bring everything on record, Lordship.
Otherwise, the court will proceed without the same.
Yes, Lordship, I have received my instruction, Lordship. I just need 10 days time to file my addition.
Not 10 days time.
Lordship, at least 8 days will be.
We'll place the instruction. You need not file affidavit.
No, Lordship, some allegations are there, Lordship. I need to bring it on
I'd like to
record.
request a short passover for the time being. My senior is engaged in a different court, therefore.
Let us senior come.
Okay, anyway,
Because this was the last opportunity and you will
Lordship,
play.
I have my instruction, Lordship. So these are some allegations against the petitioner. So I want to file it on, bring it on record, Lordship.
Okay, let the senior come. Okay. Mm.
My lord, here, Gugoi is appearing for the university. I pray for time being or maybe some other thing. He's on legs in another court.
After some time.
He's on legs actually.
He's on legs, okay, whether you're praying for after some
Maybe
time
after
or,
some time, after another day. some
or
other
another
day,
date. Yes, Mr. Hazarika?
Yes, ma'am. I have no objection, but if he is in legs, madam. On 11th, madam?
Yes.
The presence of Mr. Gogoi is required.
They have already filed their affidavit.
Yes, my lord.
Pleadings are complete.
Uh-huh.
Pleadings
Pleadings are complete.
That's also filed.
Again, some counter affidavit.
Yes, ma'am.
Okay, as prayed for by Mr. T, you have no objection, right? As for prayed for by Miss T Vapangla, list this matter again on
On 11th of June, madam.
11th or, yes, 11th, next Friday, 11th of Thursday,
Thursday,
11th of June.
public.
Which is not objected to by Leonard Counsel for the petitioner, negative, huh? And other respondents. Yes,
Here also some difficulty. There is a direction as per Lord's may kindly peruse the order dated 19/5/2026
mm.
and
It
additional.
was reflected that Advocate General of Assam submitted that the state would file a detailed affidavit.
Lordship,
Oh, that was in a prior date.
Lordship.
Justifying the incorporation of clause 3 in the affidavit which by the applicant at 9 shall match either language 1 or 2
Lordship.
with a medium of instruction. However, when the matter is the element prays that he may be given some final sentence. So now, today what happened?
Affidavit is being prepared, Lordship. Lordship may fix the matter on Tuesday next.
Acha, what about the legal petitioner's counsel?
Lordship may fix next.
This is item number
Item number 7.
NH Barbhia, NA Laskar. Yes,
Your lordship,
they want further time to file the affidavit
Next Tuesday.
next Tuesday.
your lordship, the date may be fixed, your lordship.
Okay. Mr. P. N. Sharma, learned Standing Counsel for Elementary Education submits that the affidavit is ready
Is being prepared. Lordship.
as ordered by the last order and has been sent for vetting.
Not yet. It's being prepared. By today, we'll be sending.
You will again send for vetting, that
No,
will take
no.
time.
Lordship, we'll fix the matter on next Tuesday.
Okay. Affidavit is ready and it will be filed soon. And as such, he has prayed that the matter may be taken up on next Tuesday.
No.
Accordingly, fix the matter on 9th of June.
Lordship. Much obliged.
For the time being passover, my lord. My senior is on leg as for.
After some time.
It's fine. Unless.
Yes.
This item number 10.
What about 9? Who is appearing for 9? Miss M. Das. Any idea who's M. Das?
They have filed an addition, an affidavit in reply. Item number.
You will file.
No, they have
Oh,
filed. an
they have
affidavit in
filed.
reply.
In item number 9.
My lords.
Acha, on the last occasion, she was supposed to file and bring some records. bring some documents on record. That has been filed, right?
Yes, that has been filed today, Your Lordship, because the petitioner did stay in Sivsagar, so it was with.
Okay, that is done
Yes, yes.
by the petitioner. Now what is to be done today? It can be heard, I believe,
My lords.
but then the council is not there. What about 10?
10 years, also we have filed an affidavit, Your Lordship.
Acha.
I have not.
Affidavit of in replies.
I don't know if I have been,
Even Your
I
Lordship.
don't know even.
You served the copies upon all the respondents, okay?
Yeah.
In 9, you write, none appears on call for the petitioner. 9. Acha. M. Das, you are appearing for Miss M. Das. So you have given, did you get the reply copies of Miss in item number 9?
Affidavit in reply, item number 9.
Acha, you serve the reply copy to all the respondents?
I have received the copy.
I think to the main respondent they have served, but not to the others. Okay. Your Miss S. Dave. Heard Miss S. Dave, learned counsel appearing on behalf of Miss M. Das, learned counsel for the petitioner. Also heard Mr. K.P. Pathak, learned standing counsel for APDCL, and Miss Fukon, K. Fukon for AEGCL. You are Mr. Mr. H.R. Das for APGCL. APGCL. It is stated by the learned counsels appearing for some of the respondents that they have not received the copy of the reply affidavit filed by the petitioner. As such, the learned counsel appearing for the petitioner is directed to serve the copies upon the said respondents. Fix this matter on which date? When do you want?
As per your
Any
lordship's
date.
convenience.
Yes. When can Miss S. M. Das appear? List this matter on 17th of June, right?
22nd, Your
Uh-huh.
Lordship. 22nd, Your Lordship.
22nd of June, Monday.
22nd is a Monday, my lords.
That will be a motion date.
It will take some time because they are seeking parity in pay.
So, okay, on Wednesday, 17th, try. Mr.
Why,
Kumar will not be there or what?
No. We'll be
Then
out of station.
22nd will be a motion week.
My lords.
Lordship 19.
19th, okay, Friday, 19th of June. In item number 10, you write? In item number 10, the heard Miss what is your name? Your name, please? No, heard.
B. Soren.
Your thing is done.
B.
huh?
Soren.
B. Soren, learned counsel for the petitioner. And Mr. K.P. Pathak, it is submitted by the learned counsels appearing for the respondents that they have not received the additional affidavit filed by the petitioner. As such, it is directed that as such, the learned counsel for the petitioner is directed to serve the copies upon the said respondents. List this matter on same date, 19th of June.
Here in this case, matter of provincialization.
Matter of
Provincialization of service as a tutor.
Mr. P.N. Sharma.
Here, this is the second round of litigation.
Okay, I can take it up now.
Here we have.
Here in this case, apparently, order is very illegal, because this petitioner is admitted appointed in the year 1986, and private respondent was appointed admittedly in the year 1999. Even then, my lord, with a very cryptic order, my lord, my representation was as per direction of this order without going to the core issue of this case, my lord, rejected my claim, my lord.
Okay, let me see the impugn order. It can be
Yes, ma'am.
taken up for disposal today.
Otherwise,
Yes,
we-
ma'am.
otherwise our affidavit will be required because
This, affidavit is not required.
Affidavits are filed, it seems. Who has filed?
no affidavit is filed by the private respondent. Not
Oh, today private respondent is not represented.
Here, my lord, admitted position in the earlier order also, my lord.
Wait, what about the advocate for the private respondent?
Earlier occasion, he took time, my lord, and lordship kindly will look earlier order page 38, my lord. It is admitted position of the matter, my lord. Page 38, relevant portion, my lord. His appointment.
But without representation of the private respondent, can it be heard? Who appears for respond number 7?
Some, my lord, B.U. Laskar.
Uh-huh.
B.U. Laskar. So far I remember.
B.U. Laskar.
After
is-
some time, my lord, may be taken up
Okay, after some time you bring him, call him
at 2 p.m. my lord.
at 2. No, you try now. You try. If you can get hold of him, bring him. Yes, Miss Davies.
Is your lordship, small last, lordship kindly produce the last order. Your paisa?
Lordship, we were asked to obtain instruction whether the petitioners were appointed against sanctioned post or not, Your Lordship. The order is of 20 March 2026, Your Lordship.
Mm.
The instructions are awaited, Your Lordship. We have not received the instructions yet, Your Lordship.
But see the last order?
Lordship,
Directions were made twice directing him to get the instructions.
Lordship. I
But
have seen,
then,
Your Lordship. I have gone. through.
great, not more than a week's time to get. So,
I have gone.
number of days have elapsed.
Yes.
Lordship, actually, I have,
B.
we-
Kaushik appeared on the
yes,
last
yes, Your
occasion.
Lordship.
Last
I have-
did
I
you
have-
be Kaushik?
Lordship, a week's time may be given. I have already communicated with the authorities, Your Lordship. Week's time or 2 weeks' time may be given, Your Lordship.
Not 2 weeks. Last time only 1 week time was given.
Yes.
Lordship, one.
So you bring the instruction by Friday? Day after
Friday.
tomorrow? Instructions only.
No, I.
Affidavit
Whether
is
they
not
have been
required.
working against the sanction vacant post. or
Ah.
not. That's
Simple
all.
instruction.
Yes.
Lordship,
Yes, in fact, simple
If I
instruction.
have
Only
been
whether
working
they are
against
working
the
against.
sanction
Lordship, then Monday, Your Lordship.
To regularize my service.
My-
They have been working long back, 1994, mother. Then I obtained the order in the year 2015. Then on basis of Uma Devi, mother, this honorable court passed an order to regularize the service of the petitioner. Then after 3-4 years, they have filed one review. Then review was not allowed, of course. Only one point that whether they have been working against the sanction vacant post. That instruction they won't be able to bring. That is the
Lordship, in a week's time, because today is Wednesday, next Wednesday, Your Lordship.
Thursday.
It doesn't matter also, even if I,
Hearing date Thursday.
even if I give them time and say that this is the last opportunity, still things are not worked out. This
Lordship,
is very
I'll-
sorry state of affairs.
Yes.
Lordship, I'll ensure it by Wednesday or Thursday, the.
And every day, mother, different advocates appeared, mother, sometimes.
No, whether that information is at all required. Your papers does not show that she has or he has been working against sanction post.
No, it is shown, but this honorable court passed an order
Mm.
after the review, mother,
Mm.
that the petitioner will go before the commissioner and they will show the original documents
Mm.
that whether they have been working or not against the sanction vacant post. Instead of that, they have made a committee, my dear, without the order of this honorable court. They make a committee. Then in committee, there are lots of officers are there, and they have stated that in one line that they are not working against this sanction vacant post. It is against the court's order. That's why I again approached this honorable court.
The constitution of the committee was not contemplated.
No.
Was not ordered.
There is no order like that.
Okay, since there is a judicial order, you bring the instructions.
Lordship.
There is no purpose of saying them last chance or
Yes.
because they don't keep that word. Miss D. Mushah, yes?
It's okay.
be on Monday, my lord. They can endeavor to obtain the instruction.
What endeavor? Without the instruction, we will proceed then.
Yes.
Can it be Monday or Wednesday?
Yes, Miss D. Mushahari, learned
Wednesday, what?
Standing Counsel for Secondary Education Department submits that although best efforts were made to get the instructions as ordered by this court, they have not been able to bring the same and has prayed for a week's time to get the necessary instructions. As such, list this matter on 10th of June, 2026. For instructions and on failure to produce the same, the court will proceed without the instructions.
Hello.
MK Chaudhary ka gab hai.
For the time being.
Time being. Mr. MK Chaudhary has some medical issues, I'm told, in the morning.
PP Medi, the conducting council PP Medi is on leg. He is at another court.
Okay. Let him come after some time. What happened? No counsels? Yes, Miss Fukan, you appeared. For AEGCL.
Yes.
But what about the petitioners? Some deduction is made. Yes. Again, time being. Okay. After some. Yes, Mr. Das is here. So deduction.
Only, yes, my lord, only 60,000 something, my lord,
Yes.
only because of that, and as part of my lord, recent judgment, my lord,
Hmm.
it's not permissible, my lord. Return
So affidavits are filed on behalf of 2, 3, 4, and 5.
60,291 rupees only.
So it can be taken up for disposal, right? Okay. So why has it been deducted?
Because, my lord, it was a calculation, my lord.
Or calculation was wrongly done?
Yes, my lord. According to them, my lord,
Mm.
they have issued one letter
Mm.
saying that, my lord,
Take me to the documents.
yes, my lord. That is, my lord, intimation regarding deducted amount from terminal benefit. Page 25, my lord, next and 9.
25.
Yes, ma'am.
Yes.
And this is to inform you that we have received your request application.
This is the letter to the petitioner,
No, my lord, this was, yes, my lord.
Kularanjan Das.
Yes, my lord, Puloranjan Das.
Yes.
This is to inform you that we have received your request application for payment of rupees so and so 60,291 only, which was deducted from the DCRG amount, and in response to that we have come to the conclusion that the deducted made was tenable and correct on our part.
CRG is?
That come retirement receipt.
Acha. Mm.
Furthermore, the AEGCL ordered dated an allowance dated 21/9/18 stating waiver of recovery of any payments made in excess of entitlement to the employee of AEGCL without any fault or involvement in the part of the employee. For such excess payment made cannot be made applicable retrospectively from 31/1/14 date of retirement, and hence will not be applicable in your case.
No, I couldn't get. What happened? They had given you excess amount and so they have deducted.
Yes, my lord.
And so what furthermore, order dated so and so stating waiver of recovery of any payments made in excess of entitlement without any fault or involvement in the part of excess payment made cannot be made applicable retrospectively. From hence it will not be applicable. So they are saying that the deduction is wrong.
Say, my lord, what is happened actually, my lord, in view of the judgment of the Rufik Masi judgment, one of the leading case, my lord.
No, what about the interpretation of this sentence?
Yes, my lord. Interpretation of sentence is there, my lord.
Retrospectively from
Retrospectively means, my lord, they have, my lord, issued, they have annexed one notification, my lord, office order in their, my lord, affidavit in opposition.
Yeah.
Because Rufik Masi's judgment, my lord, comes later on, my lord.
Mm.
Already he has retired. Already he has retired on when, my lord?
But this sentence is not talking of any judgment. It is in
But
power.
here in the notification it is stated.
Cannot be made applicable retrospectively.
Retrospectively. Retrospectively means, my lord, Rafik Masi's judgment comes, and they have annexed in their.
Rafiq Masi's judgment speaks of that it will be waived. It cannot be deducted.
Yes, my lord. But it cannot be, my lord, followed, my lord, retrospectively. They have said.
That
But
is after
earlier
2000.
also, my lord, Sam Babu's judgment is there. I have got this, my lord, 1994 to SCC 521. If there is no mistake on the part of the employee, that cannot be deducted from the retirement terminal receipt.
But whatever it is, you have got it,
Yes,
which
ma'am.
is not legal on your part.
Yes, my lord.
You are not entitled for that amount. So you give it back. What is that?
No, my lord, he is a grade 3 employee. It is specifically mentioned in the Supreme Court judgment, grade 3, grade 4 employee, not a single penny can be, my lord, recovered from. If the mistake is on the part of the employer, my lord. If it is the old mistake, my lord, on the part of the employer, my lord, but not.
But he was given an excess amount of 60,000, right?
60,000, my lord. That amount is very much required. That is why I have filed this case, my lord, because.
Required is okay, but then he was not entitled to that amount.
No, I'm entitled because they have given me in the earlier occasion, my lord, but Supreme Court specifically mentioned in repeat mass judgment, my lord.
Judgment has come later.
This is what they say.
But and Sam Babu
Deduction
judgment
was
also, my lord,
made-
says that, my lord.
But there is a 94 judgment, I'm told,
Yes, my lord. That is specifically
which
mentioned.
also says the deduction should not be done.
Yes, my lord. If employee is, my lord, grade 3 and grade 4, my lord. There are 4 employees, my lord, some
Huh.
amount they are drawing, my lord. And my lord, following this judgment also, our honorable High Court also, my lord, passed a final judgment, my lord. I am giving one certified copy of the judgment, my lord, saying that type of advantages.
Deduction was made on 5/5/2014 and judgment came on 18/12/2014, later part.
That Mashi's judgment.
Yes.
But here, my Sam Babu judgment was earlier there. Following the judgment.
This is Kusharam Kakoti.
Yes, my lord. It is specifically mentioned.
This is 2018.
18, my lord. 2014 judgment follows, my lord. 1994 judgment follow.
Deduction was made on 5/5/2014. earlier.
Acha, which judgment you want me to see first? This Dipendra Nath Thakuria.
Yes, I have.
This is 2015 judgment.
Yes, my lord. That is also followed, my lord.
Where is Mashi or what you are saying? Where is Mashi judgment?
Rufiq Masih judgment, it is principally it is.
This is 2015 4 SCC.
Yes, my lord.
Mashi?
Yes, page 20, my lord. Kindly peruse the last paragraph, my lord. In this say depend Thakuria's judgment, my lord. Paragraph number, my lord.
Huh.
It's not numbered the paragraph. It's certificate.
But these are all later judgments. It is not necessary for this court to enter a salary drawn by the petitioner.
In the judgment, kindly peruse the check.
Because even if it presented a salary drawn by them was in excess
5,
of the
page 5, my lord.
petitioner, it still stand
My lord,
protected
depend Thakuria's judgment, my lord.
Wait
It's
one
important.
second. No,
In
still
the middle,
stand
my lord.
protected.
However,
Where I'm reading the last paragraph of Dipend Thakuria.
yes, my lord.
Their Mashi case was relied on.
Relied on, but prior to that, my lord, in the middle, my lord, page 1.
Yes, middle which there are no paragraphs here. Yes.
5.
Huh?
Page 5, my lord.
Page 5 of the internal page.
Yes, ma'am. 1, 2, 3, 4, 5. Page 5 of the my lord, judgment, my lord. Depend Thakuria's judgment. How he has
1,
followed.
2, 3, 4. There are 4 pages altogether in Dipend Thakuria's judgment. You read the opening sentence of the paragraph you want to rely. You have already given me Dipend Thakuria.
Actually, I marked there, my lord. From however it is.
ये वापस कर दीजिए.
Yes, however,
That is.
I think that judgment is not complete, the one that you had given. Okay, however, in a recent decision, this is excess salary, right?
Yes.
And this was, in your case, it was retirement gratuity.
Any kind of retirement benefit that is specifically pointed out here. Sir. In the Rufiq Masih judgment, paragraph 18 of the Supreme Court judgment, my lord. And that is why to 1994 also followed there, my lord.
In his case, your lordship, financial upgradation.
Which one?
His case.
Acha.
Any
Let
kind
me-
of, my lord,
Let me
recoveries.
go through the judgments after referring to the various cases on the subject from Shyam Babu and all. It not that it may not be possible for all possible situations of hardship with a law. Hmm.
Seventeen, I mean 16.
Okay, then
Settled position is that, my lord, subsequently.
where is this case? Shyam Babu?
Tembago is, my lord.
Shyam Babu, have you given? Shyam Babu Verma, yes. What is the paragraph of Shyam Babu?
Tembago judgment, my lord, is, my lord, paragraph 11.
But then these are in the facts of those cases. See, in Shambabu, what had happened is he was supposed to get the upgraded pay scale after 10 years of service. Now they were given before that, before completion of 10 years. So it is not fair to recover that part in Shambabu.
Principle is that, my lord, here it is another judgment.
Why, in your case, why that excess amount was given to you?
It was wrongly calculated by them, my lord.
Where is that? Where
I
is?
mentioned in my affidavit, your lordship.
Huh? In your affidavit?
Yes,
Where?
paragraph number 4.
Paragraph number 4. Yes, we got.
I reading.
Retired from his service on modernist renewal from LA to UD in 2009. So, okay, in this case, it will be applicable. Here also, you have given the more pay because of some upgradation,
Yes,
which was actually not, should not have been allowed.
yes.
But that will come at par with Varma's case. What? This Varma or what?
Burma follows specifically in.
So, in that, this will, your Varma case will
Payment
come
was
here.
made earlier of the judgment, your lordship.
No, no, Varma is 94.
90.
What Varma or what he said?
That is, yes, this,
Shyam Babu Verma.
yes.
Shyam Babu Verma,
I
what
have
had
not gone through your.
Shyam Babu Verma, what had happened is the petitioner was paid and pay scale before his completion of 10 years of service. The requirement is that after 10 years it will be increased. But before completion of 10 years it was increased, and thereafter they wanted to recover that amount, excess amount. That was said to be wrong. So here also same. What you had said is he was promoted from LDA to UDA in 2009 from the pay scale of so and so and upgraded. However, Sri Das completed his 25 years of service before 2007. Right.
Yes.
So he becomes eligible for promotion to UDA in 2007. And therefore, second financial upgradation benefit was given to him with retrospectively from 2007, in addition to his regular annual increment, date of promotion. That is, before his date of promotion, he was granted the financial upgradation. Now, if you take back the money, that will be unfair.
A person is entitled for two upgradation only, financial upgradation during
Ah,
his time.
yes,
But
entitled.
he will get, if it is allowed, then he will get three upgradation, financial upgradation.
Where is that? And now you want to recover, you have recovered it after he retired.
Yes.
Okay, heard Mr. Where is that bar not to give three financial, what?
That rule is not with me right now, Your Lordship. I can bring Your Lordship.
So, second financial upgradation was given,
Yes.
but there is no question of third here.
With completion of 25 years, he has got second financial upgradation. And again, at the time of his promotion,
Mm.
again, he got third financial upgradation.
But that is not written here. What you have said is, you see, in your own affidavit, second financial upgradation was given to him retrospectively from 2007.
Yes.
Right.
Yes.
And which was, I think, reduced later, in addition to his annual increment. Before his date of promotion. His date of promotion was 2009.
Yes.
But you have given the second financial upgradation because he completed 25 years in 2007.
Yes.
So you have given that backdated
Yes.
retrospectively.
Yes.
It was granted, which was mentioned in incumbents. Now promotional increment given to so-and-so was erroneously done, which was therefore recovered from his terminal promotional increment. You are not saying this is financial upgradation.
At paragraph number 5, I have mentioned, Your Lordship.
So you are, what you have said is the increment given in 2009 was wrongly done.
Yes. Yes.
Because 2007 you had given him.
Yes. Yes.
the
Earlier he
second.
got, yes.
But then you have not said that this promotional increment he is not entitled for.
At paragraph number 5, Your Lordship.
Achha.
Additional increment
Has
given
been
to
granted second financial with effect. Clause 11 of the aforesaid given financial upgradation with higher duties and responsibilities after getting the scheme. No further pay fixation shall be admissible, and concerned employee shall then be allowed the designation only to the post to which he is promoted.
paragraph number second paragraph, Your Lordship. As mentioned in
Paragraph 5 you said?
yes, yes.
Achha,
In
achha,
paragraph
achha.
number 5, second paragraph.
4 I am reading.
Yes.
Financial upgradation and this annual increment is the same thing. No.
No.
No,
Annual increment, that is per year.
yearly.
The one has said that additional increment given to Sri Das on his promotion will you need. But in 2009, you were given again some financial benefit.
Yes.
But you are talking of,
because of his promotion.
but that is not financial upgradation, that is promotional increment
Promotional increment, yes.
given in the year 2009.
I
This-
need little bit clarification, Your Lordship. One more date may be given. I'll bring the
We have already seen the entire matter.
1 week time may be.
But this is, where is the rule? You should have been ready with all this. But this promotional increment and financial upgradation is not the same thing,
Yes,
right?
same thing, madam. And
It's the
what
same thing.
that is not, no, my lord. That is different. Promotion is different, my lord. Annual increment different, my lord.
Promotional increment is what?
Promotion, after promotion, he will get the increment, my lord.
But that was given prior.
That
He was promoted in 2009.
yes,
But
madam.
what
But-
financial upgradation was given with effect from 2007? Because he was entitled
Yes, my lord.
after 25 years.
Yes, my lord.
So what promotional increment was given in 2009, that was sought to be recovered. Now promotional increment and financial upgradation is same. Cannot be.
Cannot be, madam.
I'll take it up at 2, you get the instruction.
After 3 days, Your Lordship.
No, at 2.
Next Friday, Your Lordship.
No, at 2. I have gone through the entire matter, now I'll not remember. This is waste of time.
Principle
Okay.
is that, madam, nothing can be recovered from the grade 3 and grade 4 employee.
But what she is saying that there is a bar, that third,
No, no.
Yes,
That is not,
I'll bring
that
it.
is not, it is also mentioned in their affidavit in opposition only because of the Supreme Court judgment, my lord. Rafiq Masi,
That they say.
that is mentioned, only mentioned on 18 December 2014, Honorable Supreme Court of India delivered the judgment so and so. But prior to that, another judgment was there, my lord, numbers of judgment. And following this judgment, I
No,
have.
your main ground is that Rafiq judgment has come
Yes.
later.
that
You
is-
see your paragraph
Yes, yes.
5 later.
Hmm.
On 18th of December, this judgment was delivered.
Yes.
The recovery of overdrawal of pay and allowances due to wrong fixation of pay to grade 3 and grade 4 employees cannot be made. However, in the said order, there was no mention related to similar cases occurring prior to the judgment. It is not made retrospective. This is what you say. Again, Mashi. Okay, right. Heard Mr. H.R. Das,
This does.
H. Das, learned counsel for the petitioner, and Ms. K. Fukon, learned standing counsel for AEGCL, and anyone else? No, right? You are for? On behalf of us, APDCL. Okay, Miss so and so for so and so appearing for the APDCL. By this application filed under Article 226 of the Constitution of India, the petitioner has prayed for quashing for setting aside and quashing of the impugned order dated 3/2/2014. There are two orders. And order dated 29/6/2024, issued by the Chief General Manager, AEGCL, by which where is that impugned order?
Improve
Annexure 5?
Yes, for the page 25, annexure 9.
Acha. Page 25.
Yes.
Yes. This is 29/6/2024 order. And you have challenged two orders.
Two
Where is Annexure 5?
Earlier also, my lord, they have issued letter, my lord.
3/2/2015.
Yes.
And page 17.
Yes, yes. Yes, my lord. Annexure 5.
This was before his retirement.
Yes, before his system.
No, no.
After. Covered from the benefit of, yes, ma'am. It was issued on, during the period of retirement.
By which? As per order dated so and so, the refixation of so and so is made and overdrawal amount of rupees so and so only to be recovered from it. By which by which an amount of rupees 60,291 was sought to be recovered from his terminal benefit. By the earlier order dated 3rd of February 2014. And no, you do one thing, by which set aside and quash the impugned order dated 3/2/2014 kuch na, wo bola tha na, by which, that line you write, by which an amount of rupees so and so was sought to be recovered from his terminal benefit. ठीक है? Full stop. The petitioner has also prayed for, वो line खत्म हो गया? The petitioner has also prayed for setting aside the order dated 29/6/2024 passed by the Deputy General Manager, Pension Section, by which the request made by the petitioner for payment of rupees 60,291, which was deducted from his DCRG amount, was rejected. The releasing the actual mention on this. It is also prayed that the authorities may rectify the actual pay scale and release the actual pension on the basis thereof. It is the case of the petitioner that he retired on 31st of January 2014. And immediately after his retirement, an order was issued, which is impugned in the present petition, that an amount of rupees 60,291 will be recovered from his terminal benefit, and that refixation would be done by the authorities. And thereafter it was deducted, right?
Yes, madam.
It is the further case of the petitioner that the said amount was deducted by the authorities concerned. He as such made he as such made an application. Yes, Mr. Counsel?
Yes, madam.
Where is that application?
Application, my lord.
Annexure 7.
Yes, madam.
He made an application to the authorities concerned.
7 and 8.
Hmm.
Exercise.
Concerned to give him back the said amount by his application dated. No, application likha na? On 2/5/2014, as well as on 5th of August 2024. No, that was dated what? Oh, 5th of March 24 likho.
Two applications.
Two application. One is 5th of March 24. Same date
No, madam. Oh, first one is
to the general manager. Okay.
March 24, and
No.
second one is 5th of August 24.
Oh yes, 5th of
7 and 8.
August 24. And 5th of August 24. The first representation was made before the General Manager Pension section, and the second application was made before the President Secretary of AACB. Para. It is seen that by the impugned order dated 29/6/2024, the petitioner was intimated that his request cannot be acceded to in view of the fact that waiver of recovery of any payments made in excess of the entitlement was ordered after he retired from his service. The order was by the Honorable Supreme Court. In Mashi, right, which is the case in Rafiq Mashi, in state of Punjab versus Rafiq Mashi. No. Rafiq Mashi, right?
Yes, sir.
State of Punjab versus Rafiq Mashi, reported in 2015 4 SSA
334.
334. Wherein the apex court had held. Na lage, wo baad mein रहेगा. So it reported in so and so. And the learned counsel for the petitioner submits that even before the case, even before the judgment delivered by the apex court in Rafiq Mashi's case, there is a judgment delivered by the apex court in Shyam Babu Verma versus Union of India, reported in 1994 2 SCC 521, wherein it was held that any excess payment made for no fault or made to the employee for no fault of the employee cannot be recovered by the authorities concerned. As such, he submits that, full stop. As such, he submits that in the instant case, the same analogy is applicable and no amount can be deducted from any account of the petitioner after the same has been paid for no fault of the employee petitioner / petitioner. On the other hand, the learned counsel appearing for AEGCL has filed an affidavit wherein it was stated that the excess payment has been made to the petitioner erroneously and the same is recovered from his terminal benefit later. It is stated in the affidavit that during the tenure of the petitioner, during the service tenure of the petitioner, while he was promoted from the post of LDA to UDA in 2009, his pay scale was increased, however, it was seen that on completion of 25 years of service, the petitioner was entitled for his second financial upgradation benefit, and that the said 25 years of service was completed by the petitioner in 2007. Although he was promoted in the year 2009, and that the second upgradation benefit was given to the petitioner with retrospective effect, that is from the year 2007, in addition to his regular annual increment, regular annual increment. Full stop. It was also mentioned that promotional increment was given to the petitioner in the year 2009 again, which, according to the respondent, was erroneously given, since the upgradation benefit was made retrospective, was given retrospective effect from 2007. It is further stated that the judgment of the Honorable Supreme Court was delivered in Rafiq Mashi within bracket Supra case was on 18th of December 2014, which was after the recovery, right? It was after the recovery, which was after the recovery made in the instant case from the petitioner. Full stop. As such, the learned counsel appearing for the respondent submits that the said case cannot be applied in the present application. Para. In Shyambabu's case, Supra, it was held by the apex court that the petitioners in that case, were entitled to a pay scale, to an enhanced pay scale after a period of 10 years of service. But the pay scale was enhanced before the said 10 years of service, which was sought to be recovered. Oh, no. 10 years of service, right? For no fault of the petitioners. Full stop. In the said case, the scale of pay was reduced later, and the excess amount given to him was sought to be recovered. However, the apex court directed the same cannot be done. The facts of the case in Shyambabu Verma's Supra is similar to the instant case as projected by the learned counsel for the respondents. Apart from the said apex court decision, there are other judgments given by this honorable court. Full stop. One of such judgment is, this was delivered in 2015, Mr. Counsel. 2015, Dipendra. Any case before 2014?
By relying the judgment of the Shyambabu, that is, I have given 116 judgment, my lord. My lord, Justice Bujur Burua.
Justice Ujjal Miya?
Bujur Burua, my lord.
Bujur Burua.
Yes, ma'am. By following the said principle of paragraph 11 of the Shyambabu.
फुल स्टॉप के बाद लिखना, काट दो वो लाइन. नहीं रहने दो. One of such judgment is one of such judgment is delivered by this court in Dulal Chandra Borua versus State of Assam, reported in 2017 3 GLR 499, wherein by applying the ratio of Shyambabu's case, it was held that if an employee receives a pay scale higher than what he is entitled to for no fault of his, it will not be just and proper to recover any excess amount paid to him. In the instant case, it is seen, as is reflected in the affidavit in opposition, that the petitioner becomes entitled for his second financial upgradation benefit on completion of his 25 years of service, which he had completed in 2007. And as such, the said benefit was given to him retrospectively from the said year. Although, no, said year, full stop. Thereafter, the petitioner was promoted from the post of LDA to UDA in the year 2009. And in 2009, a promotional increment was given to him. Which is before the second financial upgradation benefit given to him retrospectively. They said promotional increment given to him in the year 2009 was not due to his fault. It was given by the authorities as mentioned in the said affidavit. Accordingly, it is seen that further, it is held by the Honorable Apex Court that any excess payment given to an employee for no fault of his cannot be later on deducted by the authorities concerned from his terminal benefit or otherwise. In view of the same, this court finds it fit to set aside both the impugned orders dated 3/2/2014 as well as 29/6/2024. It has not been it has been deducted, right? 24. In view of the same, and the amount of rupees, and the amount of rupees 60,000 what?
200, my lord. Yes, 60,000.
An amount of rupees,
21.
yes,
200.
60,291, which was deducted from the DCRG amount of the petitioner, should be paid back to the petitioner by the authorities concerned. The petition is accordingly allowed and disposed of. You can take back the judgments.
Yes.
I've received my instruction, Lordship. I will allow 2 weeks time to file my affidavit, Lordship.
Lordship, otherwise this is a very, this matter is
Yes,
pending since
Lord,
2024.
I
Immediate
received-
grievances.
And this matter has come up after more than a year.
Yes, Lordship. I have received my instruction 2 days back, Lordship.
Okay, let them take, well, you will file affidavit.
I am not filing.
And there was only one order. You have not tried to bring the matter on
No,
board
my Lordship,
also.
we had tried, but somehow it has
Not
not
yet.
been listed.
Okay.
Lordship, what I'm saying is this, Lordship, we have very limited grievances. We are challenging this seniority list for rectification of the seniority list. We want the rectification.
Mm.
If they have the instruction, it can be disposed of today.
No, Lordship, I will file my affidavit because, Lordship, the other persons, Lordship, who are given seniority are not party here, Lordship. So I have
Doesn't
to-
matter. He is not claiming relief against them. There are judgments of Supreme Court that those candidates, because they can go for appeal.
Lordship, just
They
one
can
day.
go for appeal being affected by the judgment, but against them, he has not claimed anything. So in that case, they may not be parties. I have referred the
Lordship,
Supreme Court
Lordship,
judgment in one of my decisions.
Anyway, Lordship, may give me
Okay. Mr. Upadhyay, Learned Standing Counsel for
irrigation.
Irrigation, submits that he be allowed some time to file his affidavit in opposition. Prayer is allowed.
2 weeks, Lord.
Lordship, a date
Full
may be
stop.
fixed, Lordship.
Since the matter pertains to 2024, this court allows him 2 weeks' time to file the affidavit. List this matter on 17th of June.
17th.
List this matter on 19th of June.
Lordship. All right.
I'm okay.
Next to next Friday.
Lordship.
Lordship,
Yes.
here we have filed one affidavit.
Acha,
of the
today that matter is fixed, that
Yes, Lordship.
compensatory appointment,
Compassionate appointment. yes.
compassionate appointment, yes.
Yes,
Okay,
no,
we will
I-
take it. It is down the list or what?
It is mentioned as at two.
Oh, at 2.
Yet two it is mentioned.
Yes, what is to be done here?
Lordship, kindly take up next week, Lordship. The appellate authority, they will be filing affidavit. Everything is ready, Lordship. Just
Disciplinary
receive it.
authority has filed.
Yes, it is filed, Lordship.
It is registered on my service man. It is good enough.
You have prayed for reinstatement.
Registered man.
Appellate authority will file. Appellate authority has rejected your
Yes.
prayer, right?
My
After,
lord, I want to give some permission, my lord.
Hmm.
My lord,
Okay, sometime we will take it up next week.
Huh?
Or week after that.
Hmm.
The appellate authority is required to file an affidavit, it is said. Because they need to give us
My lord, my lord, kindly see, page 40A,
48.
40.
Yes.
40A, and page 60, my lord.
48.
40A.
Huh. Yes.
Medical certificate, my
So
lord.
written statement, this is your
48.
written statement.
Huh?
This is your reply.
This is reply.
Hmm.
So, my lord, this medical certificate is, my lord, something it is seen that handwriting without arms.
Without?
Arms. But it all are printed without arms.
Hmm.
He is fit for service without arms, medical certificate. And
Fit for service without arms.
without arms.
So he'll not be given arms. He's a constable or what?
There's a constable.
Okay, let the appellate authority
Yes.
file, or without that
The
affidavit, it
record
can
may
be
called
taken
for,
up.
my lord.
Huh?
Medical records may be called for, my lord. And my lord, page 60, my lord. Page 60, my lord. Kindly see para 2.
Hmm.
Moreover, I have considered his past service, wherefrom it is also come light that prior to DP, the delinquent has
Has
5
spotted five
DPs
numbers,
against him.
5 more DPs
So and
against
so,
him. There were 5 more
so
DPs against
he
him.
was
So many
dismissed.
DPs, so many irregularities.
So many, he's a habitual
He-
offender, Lord.
for his cowardice, but Honorable High Court was pleased to reinstate him.
Ah.
But
For his cowardice.
uh,
So he was a coward.
uh,
Acha, anyways, we will see.
that my lord, I filed an RTA application. What is the order? What is the order of the reinstatement order? But the
Commandant had filed the affidavit from appellate authorities who?
but
Yes,
they
Lordship.
did not
Hmm?
reply. That there is no any record. regarding
Acha,
that-
let the appellate authority file the affidavit. We'll take it up for final hearing. Okay. Miss M. Bhattacharjee, learned additional senior government advocate, submits that the appellate authority. What is the appellate authority here?
Here, Lordship. The Inspector General of Police.
Appellate authority, that is
TNAP,
the Inspector General of Police. Which place?
TNAP, Assam.
T
And AP.
TNAP. TN. And is A and D.
And is and.
A and D. T and AP. What do you say?
It is mentioned in the, these things, Lordship. Respondent
Appellate
number
order.
3.
Huh?
Respondent number 3.
Respond number 3.
Yes,
Yes. Wait. Any appearance on their behalf?
No. I
You
am
will appear.
representing everyone, Lordship. 4 has filed, now 3 will be filing, Lordship.
Okay. Miss M. Bhattacharjee
They will
submits that.
send immediately reply. I will file.
Inspector General of Police within bracket T and AP. Assam may file an affidavit for the proper adjudication of the case. Prayer is allowed. List this matter on 19th of June.
Lordship, he also wants to file reply, Lordship.
I will also file a reply, my lord. 19 is not.
It is further prayed by the learned counsel for the petitioner that in the event of filing of an affidavit by the appellate authority, he would also file a reply to that, if required. Prayers are allowed.
Then after the vacation, Lordship.
List this matter on 17th of July.
Lordship.
July.
70 of them.
17th of July. Okay.
Obliged, my lord.
Deeply obliged, Lordship.
Okay.
21. Mr. B. Chakraborty, you have something to say? Yes, Miss Brown?
Matters become infructuous because there was no stay order. The person went there and joined at Delhi, Lordship. His
Acha,
only
the-
ground was that he did not complete 3 years, and by this time 3 years has already been done. There was no stay order also. He went there and joined at Delhi, which being one of the choice posting preferred by him.
Oh, it was a transfer matter.
Transfer matter.
And then he went and joined.
And joined there, since there was no stay order.
So
No, your lordship. So now
he will again come back over.
so my limited prayer here is that he has already given a representation, your lordship.
That may be
So basically, what has happened is that the respondent authorities had rejected his application, his appeal on the ground that he had not completed 16 years at his, at the out of station posting. So at the time when he was transferred, he had completed almost 15 years. Now, while this matter was pending, your lordship, now the 16 years are also going to be completed
Over.
another 11 days. Another 11 days, he completes 16 years as in his out of station posting, your lordship. So right now, your lordship, our limited prayer is that his appeal may be considered so that he can be posted in his home station, your lordship.
So 16 years he has been outside.
Yes, now in another 11 days, it will make 16 years, your lordship. And by their own admission, it was the reason for him to be transferred was because he had not completed 16 years.
He was transferred from where to where?
From Duliajan, which is his home station, to Delhi.
To Delhi,
Yes. So,
which you had put to challenge.
yes,
On the ground?
on the ground that he had already appealed to the respondent authorities on the ground that his wife is bedridden. And the status of the wife is such, whatever surgery that she had gone through, after that it is degenerative in nature, your lordship.
So he has, so he
Bedridden.
objected to his transfer to Delhi. So he wanted to stay in Duliajan
Yes.
or any other place of posting or what?
No, home station.
Home station.
Yes.
This is
Because
oil,
No, CISF.
CISF. Okay. So now he had gone, because of no stay order, he had gone and joined in
Yeah.
Delhi.
Because he had to join within 15 days from the date of movement order. And in the meantime, when he had filed the case before this honorable court, so those 15 days would have been completed. So he had to join.
So
which is-
he filed this case after 15 days of his
No, no,
transfer order.
No.
Before
within-
that.
Within 2 days.
Yes, but no stay order, and
No.
so he went and joined.
Yes.
Now that 16 years period is over,
Will be over in
over
another
in
10
11
days.
few
Yes.
days.
Yes.
So what is the 16 days mandatory, 16 years mandatory period?
No, 16 years to be outside the home station. There was some clause in.
So after 16 years of service, he has to be brought back to his
No,
home
not
station.
necessarily. That's
Not
only.
necessarily, but he has a
He
right.
can-
He can file a petition before that. And moreover, one thing, the appellate, the order by which his representation was disposed of, that has not been put to challenge in this writ. Or either he had to file a fresh writ petition, that has not been done.
No, representation only.
That was disposed of, Lordship. Dismissed, prayer was rejected. Ought to have been challenged that. Order
No, the
dated
rejection-
27/5.
The rejection order.
No, she has challenged the promotion, the transfer order.
At the same time, she filed an representation also that has been rejected. That ought to have been challenged.
Yes, so your lordship, we had come against.
That
the
need not be
rejection order.
challenged. That can be put as a information before this court that her representation
Anyway,
is
one
rejected.
obstacle would be there, Lordship.
So now what is to be done? You said infrastructures that she's refusing. Then what?
No, your lordship, so we have put in a petition, your lordship, that our transfer may be considered at this point of time, because in another 11 days, he completes his 16 years. And by their own admission, they have said that the only reason that he was transferred was because he had not completed 16 years out of stations.
But then he was here only before the transfer.
He was here, yeah,
He was here.
yes, he was here. But he had to be.
At any point of time, he was outside the
Yes,
home
before that
station.
Also he was.
Uh-huh.
Before that also, prior to that also he was, and then he was.
He was
posted-
outside, out
was.
of the Assam, out of the state.
Yes, yes. out of-
Lordship, page 22,
Hmm. Page 22 is affidavit.
9, now of the writ petition.
Hare, page 22 is the copy of the affidavit. Maybe the
22
23.
of the writ petition, Lordship.
23.
Page 22, his posting details.
No, there are something wrong with the pagination.
Okay, wrong one, na? Lordship, I brought the wrong file. He filed 2 writ petitions, Lordship.
Acha.
Let him be taken day after tomorrow, Lordship.
Huh?
Day after tomorrow. He
This
filed
one?
2 writ petition he filed.
No, the prior.
You can take
the
hers.
previous writ petition?
You can take hers.
Yes.
In the earlier writ petitions, as
Hmm.
per the details, Lordship,
Hmm.
out of 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10 posting, 1, 2, 3, 4, 5, 6, 7. 7 posting was within northeastern zone.
During his service
Yes,
career.
Yes, Lordship.
7 within
Out
the
of 10
state.
posting,
Huh.
7 was within northeastern zone.
Acha. Then, and what about others?
That
What-
will be around 13 and 8. 21 years is within northeastern zone.
21
So
years.
we have to maintain all India level. CSF has to maintain all India level representation,
But that was your mistake.
Lordship.
But after 16 years,
He'll be entitled to file a representation.
So, your
Let him
lordship, but
file.
also in the affidavit, they have not stated that he was in the northeast zone or not. Your Lordship, and whether that.
That is from
counted as
apparent from
station.
the earlier writ petition record.
Why
From
two
station.
writ petitions?
Your Lordship, initially on 4/4/2025, the transfer order was passed.
Hmm.
So the petitioner came before this court and the court had directed that the appeal of the petitioner may be considered.
Hmm.
But however, when he put in the appeal, then it was rejected.
Hmm.
So which is why he came again challenging the rejection.
Oh, that the earlier writ petition is disposed of.
Disposed of.
I thought both of them are pending. So what has to be done now? He or she will file an representation before
That
the
may be
authority.
considered
Now that the circumstances has changed.
Circumstances have changed, and also, Your Lordship, there's also a draft circular. So initially it was under the 2024 circular. Now there's a draft circular which will be notified very soon. And as per that circular, he has to only complete 14 years.
But draft circular is not,
Yes, Your Lordship.
cannot
I'm
be.
just bringing it to Your Lordship's.
What is the regular circular in this field?
Otherwise, that has been annexed to the writ petition.
Yes, it
So
is
which provides a 16 years of service?
16 years.
After 16 years of service, one can be posted in the home station.
Yes.
Right.
Yes.
So
It
now
cannot.
that there are few days only for 16 years,
Yes.
so you make a fresh representation before the
Your
authorities, they will
Lordship, he has
consider.
already submitted one
Huh.
on 19th April, 2026.
But then that time it was too early to give that 16 years have
Yes, Your
elapsed.
Lordship, it would have taken time also. So he had already put in his.
Now that
representation.
after 16 years you make a application, you make a representation,
That's represented.
Yes,
fresh representation after completion of 16 years,
Yes, Your Lordship.
few days, after few days. Okay. Heard Miss M.K. Brown, Learned Counsel for the petitioner, and Mr. B. Chakraborty, Learned CGC. By this application filed under Article 226 of the Constitution of India, the petitioner has prayed for setting aside the transfer order dated 4/4/2025, by which the petitioner was transferred to Delhi NCR from Duliajan. Full stop. The petitioner has also prayed for setting aside the order dated 27/5/2025, by which the appeal for stay of transfer order was rejected. And full stop. The petitioner has also challenged the subsequent orders passed by the respondents to effectuate the posting of the petitioner to Delhi, NCR Delhi. Full stop. It is also prayed that the petitioner being in his place of posting, that is in Duliajan, for less than 3 years, should be posted. It is further prayed, no? Should be posted in the said area, in the said place. The case of the petitioner is that he was working as Assistant Sub-Inspector in the IOCL Duliajan, Moran sector. And while he was working in the said capacity, a transfer order was made on 4/4/2025, transferring the petitioner to Delhi NCR. The petitioner states that he had not completed his 3 years of service in his last place of posting, and as such, he should not have been transferred to a station outside the state of Assam. The Learned Counsel for the petitioner, Ms. M.K. Brown, submits that the petitioner, being aggrieved with the said transfer order, had filed the instant application before this court, challenging the said transfer. Already challenging. person, read the last line. Not Jehovah's, challenging the said transfer. The said transfer order was challenged on the ground of medical emergency of his wife. And also for violation of the rules which prescribed 3 years, which prescribed minimum of 3 years service at a particular station. Mr. Chakraborty, learned counsel, learned CGSE has however submitted that as per rules, after 16 years of service, an employee can request for his transfer to his home station, and that the petitioner will complete his 16 years of service.
Lordship, it's about sector,
Uh-huh.
home sector.
Home sector, home station, no. Home sector. And he submits that the period of 16 years, ki boli kolo last of years of service within a few days from today.
And he has completed 21 years in this northeastern sector, home sector.
Full stop. He further submits that the petitioner has, so 21 years.
That is home sector.
So it is much beyond 16 years. What happened?
And he is seeking in this sector again to consider.
No, what you said is after 16 years of service, total service, he can opt for coming back to his home sector. But then you said home sector, he was there for 21 years.
Yes.
So,
And
matlab,
anyway, Lordship, Delhi is one of his choice. There's option exercised by him.
okay.
No, Your Lordship, but there's no clarity in regard to whether that Northeast region falls under the home sector or not, Your Lordship, because they have never. taken a
Northeastern
stand
says
at,
now Nagaland is not my home sector. Right. Northeast region may not be the home sector.
Lordship.
And nowhere they
He
have
belongs to
stated
the
in
state of Assam.
Assam.
Lordship is except one, all are within Assam. Jorhat, Bongaigaon, Nazira, Gauhati,
Those will be his
Toyong.
home sector.
Nazira, Duliajan.
Now,
All
what
are
is home sector? Has it been defined?
Any,
Near to his home. Near to his home, I think.
Lordship.
He further submits that the petitioner has served in the northeastern region for a period of 17 years.
21 years in
years.
total, out of 36 years of service.
Out of his 36 years of service.
And Delhi is one of the option exercised by him prior to this transfer.
He also submits that Delhi is a place of posting which
Opted by him.
which the petitioner has opted on his entry into the service,
No, when this
Oh, acha,
request
but
for transfer
opted-
was made.
which the petitioner had opted.
Your Lordship, if I may just clarify, Your Lordship, if Your Lordship sees page 83 of their affidavit.
I've not seen anything here on the basis of yours.
Yes, Your Lordship,
83.
83.
She is a
Page 83.
lady.
No,
No,
Acha. Oh, wife. 83.
of the affidavit
Eight-
filed by the.
There is no page 83.
In my one, it's marked 83, Your Lordship,
You are talking of his affidavit.
of the affidavit.
There is no affidavit here. What happened? This is the only petition copy.
Lordship,
Affidavit is not brought on record.
filed on 1310.
Haha.
1310.
No.
It shows in the this website.
In the website.
website.
No affidavit is received by the section from the petitioner. No. MOA has been filed by B. Chakraborty. MOA is Wakalat Nama.
Memorandum of appearance.
Oh, memorandum of appearance. Really, no affidavit.
It was filed on 1310. I checked it out, Lordship, from the website.
But not on records. Sometimes website shows, but it is not put on records. So what do you want to place from
Your
the?
Lordship, if Your Lordship can just have a look, I marked it.
Mm.
Your Lordship, by their own admission, they are saying that the petitioner had served for 14 years, 11 months and 8 days in the out-of-home sector.
Out of home sector.
Yes.
So
out of-
maybe that includes your Upper Assam areas.
Yes, it could be. So there's no clarity. in
It's
regard
okay.
to
I've
that.
said 21 years in the northeastern region.
Yes, Your Lordship.
Okay. Further, he submits. What were your submission, Mr. Chakraborty? Oh, yes, opt for Delhi, right? Full stop. Para. It is noticed that petitioner has served how many years?
21 years,
No, how total?
36 years.
Has served for 36 years in his service tenure. And by now, he is entitled to be posted in his home sector as per the rules. Where is the rule? 16 years outside service can come to home
Yes,
sector?
Your Lordship. It's at page page 26, Your Lordship, of the writ petition.
Okay. First tenure, 10 years.
First
Second,
tenure, 10 years, which is out of home sector. And then Your Lordship will see the third tenure, 6 years. The third tenure, 6 years. It has to be out of home.
third tenure
Yes.
will be of 6 years.
Yes.
So first tenure, basic training period. Posting during this period will be 3 years duration, each with option to extend tenure on request of out of home sector. So the first tenure for the 10 years, he has to be out of home sector.
No,
After the basic training.
After the basic training,
Yes.
He'll have to be outside the home sector.
Yes, and which he has already done.
Okay, second tenure, 10 choices of location.
His preference.
Remaining service, now though he has only remaining service of what?
2 years, 11 months or something. So less
He
than
will be
2 years.
retiring after 2 years something.
Yes,
So remaining service,
yes.
oh, few months are there. The personal superannuating within 2 years will be asked to submit 3 choices of so that has not come
No,
yet.
that has not come yet.
now,
So you are in third tenure.
Third tenure.
no, you'll be now around 58 years, Lordship,
Within 2 years, he will be superannuating.
Lordship.
Yes,
50, 60. So,
2029, April he'll be superannuating.
so few months are there, I think. Okay, he'll be in third tenure rather. কি করলো? Homes, provide by the rules. Provided by the guidelines. It is guidelines, right? It is provided in the guidelines dated 23rd of September 2024 slash circular number 7 of 2024 that the third tenure provides that an individual will be posted but here too during are you in the third tenure?
Lordship now will be entering the fourth tenure.
Fourth tenure only. Eto likha ki kono third tenure no hoy. Rules kori guidelines kori full stop dia. Full stop. It is noticed that the petitioner would be entering his fourth tenure being 58 years of age as of now, which shows that he has approximately 2 years of service left in his service career.
Your Lordship, it will be a bit higher than 2 years, less than 3 years. Yes.
So approximately about 2 years. Falling short of few months. Falling short of few months. As such, it is seen that the petitioner would be entering into his fourth tenure as per the guidelines dated 23rd of December 24 slash circular number 7 of 2024. Full stop. The said guidelines provides that a person superannuating within 2 years will be asked to submit 3 choices of location, including the home sector, in order of preference, and he or she can be posted to a location of choice based on his merit. It is further provided in clause 2 of guideline number what? 1. It is provided 2. It is provided in clause 2. No, it is provided in guideline number 2.1 within bracket E within bracket small Roman 2. So this is 2.1 E2. That if the remaining service of an individual is more than 2 years, he will be asked to submit any 10 choices of location, including the home sector. Full stop. It is therefore seen that the petitioner has a service of little more than 2 years, and as such, he can opt for his home sector during his final years of his service career. As such, it is directed that the petitioner may submit a that the petitioner should submit a representation before the authorities concerned. Who is the authority? Concerned, that is DGP,
Lordship. Director General.
Director General of Police,
No,
No.
Director General, CIS.
Director General, Central Industrial Security Force, to consider his transfer from Delhi to his home sector, as he had not more than, as he has only 2 years and few months in his service career. The said authority will consider the said application
As per existing policies, Lordship.
in in view of the facts narrated above and as per the policy decisions within a period of 2 months from the date of receipt of this order.
Submission of the certified copy.
From the receipt of the certified copy of this order. The petitioner is directed to place the certified copy of this order at the earliest before the
Along with the representation.
along with the representation. Petition is disposed of.
Much obliged.
Oh. Over. Item 22. Yes, 22.
22, we have received the instructions. We'd like to file an affidavit.
You'll file an affidavit?
We'll file, madam.
Okay. Mr. D. Gogoi, learned standing counsel for
Assam Agriculture University.
Assam Agricultural University.
Yes, madam.
University submits that he could require some time to file the affidavit and that he has got his instructions in the instant matter. Prayer is allowed. List this matter on.
We fix a date, Lordship, as per convenience.
You tell Mr. Gogoi.
July, my lords.
July.
After vacation.
Yeah.
If possible, 1 day before the vacation.
Oh,
Is
my
this
lords,
matter
it won't
on
be
24th of June? 3 days.
We'll
But then that will be a motion week.
motion day, my lords, it won't be listed also. Immediately after
Then
opening,
immediately after.
opening month.
On 13th of July.
13. Okay. Oh.
Dear Lordship.
Yes.
Lordship, here I am appearing on behalf of Mr. R.M. Das, Your Lordship. Though we have filed affidavit in this matter, Your Lordship, there is subsequent development as alleged by the petitioner that the petitioner name is not in the gradation list. He is in the interim order, Your Lordship.
He has an interim order.
Yes,
Yes.
there's
Your
interim
Lordship.
affidavit.
Okay, you will file your affidavit.
Lordship, we have not received till the instruction. We need some more time to complete our instruction, Your Lordship.
My lords,
Okay.
because I was under the directorate. They send me to the district, which is contrary, my lords, cannot be done. Otherwise, let her complete the instruction and file whatever
Okay.
it is, my lords. Let the interim continue, my lords.
Okay, yeah, Miss
Ardeka.
R. Deka, learned counsel appearing on behalf of Mr. R.M. Das.
yes.
R.M. Das, learned standing counsel for Water Resource
Yes.
Department, submits that they are yet to receive their instructions from the concerned department and as such prays for some time. Prayer is allowed. Please this matter on.
2 weeks time, ma'am.
list this matter on 19th of June.
Interim to continue.
Interim order passed earlier shall continue until the next returnable date. Affidavit may not be required. If we get the instructions, we can use it.
Offline.
My lord, twice, my lord, DLC, my lord, sent name of the petitioner for provincialization. But SLC, my lord, did not took proper step in the matter. My lord. Therefore, petitioner.
So, Mr. P.N. Sharma, why
My lord,
SLC is sitting over?
One similar order, my lord, I have passed, annexed, my lord, page 20, my lord.
No, affidavits file. No, not required.
Affidavit is not yet filed, but if my learned friend is agreeable to prefer an appeal, similar order, then your lordship may dispose of with the direction.
What is that similar order?
My lord,
from
page, relevant portion, my lord, I am showing page 24, my lord.
24.
24, my lord, I have annexed one order, my lord.
Huh.
Here, my lord, under similar circumstances, my lord, petitioner was allowed to submit, my lord, appeal before the, my lord,
Individual representation before the secretary.
yes, ma'am. And subsequently, my lord, referring to this order, my lord, another order is passed, my lord, very recently, my lord.
Same order. Let him prefer an appeal under section 14, lordship.
So here also SLC did not recommend.
Recommend.
This is after. Same facts.
Only school name would change, my lord.
Mm.
Here, my lord, his school name is, my lord, MA law score and SA law score.
Mm.
Page 6, paragraph 4, my lord, given spot, my lord.
Okay. Heard Mr. Barbhia, heard Mr. A.M. Barbhia, learned counsel for the petitioner, and Mr. P.N. Sharma, learned standing counsel for elementary education. By this application filed under 226 of Article 226 of the Constitution of India, the petitioner has prayed
For consideration of his provincialization benefit, my lord.
Huh.
Page 6, para 4, my lord, given spot.
has prayed for a direction to the respondent authorities to consider the provincialization of the petitioner service as grade 4 in MA law score and SA law score, ME school Kashipur, Kachar. As per the provisions of Assam Education Provincialization of Service, it was at 2018 Act. The case of the petitioner is that he was appointed as a grade 4 employee at the aforesaid school by recommendation of the school managing committee on 10/8/2008. And that since then, he has been working regularly in the said post. It is the further case of the petitioner that though the post of the petitioner as grade 4 in the said school was found eligible, as per the provisions of 2018 Act, I got in shortly go 2018 Act, and whose name was forwarded by the district elementary education officer, come member secretary of district scrutiny committee for provincialization of his service, along with other staffs, to the government. But the service of the petitioner was not provincialized. Whereas other grade 4 staffs of the same list were provincialized in their services. He further submits, full stop. The learned counsel for the petitioner submits that the petitioner is eligible for provincialization of his services as per law, and that this district scrutiny committee, after verification of his documents, found him eligible for the said provincialization and forwarded his name. But the state level scrutiny committee, where is the rejection order?
Not rejection, it is, my lord, no result thereafter, my lord.
Uh-huh.
Thereafter, no step was taken, my lord.
And this recommendation was 22.
22, my lord.
Acha, many years have gone. But the state level scrutiny committee had not acted upon such recommendation. Even after almost four years, even after the expiry of almost 4 years from the date of recommendation by the district level scrutiny committee. He submits that the further scrutiny by the SLSC has not been done till date. Para. It is no res integra that if the employees are found eligible for consideration of provincial, if employees are found eligible for provincialization of their services as per the mandate of law, the same should be followed. Full stop. The petitioners herein are stated to be eligible as per law, but their cases are not considered by the SLC, although recommended by the district level scrutiny committee. Para. In view of the above, the petitioners are therefore directed to submit petitioner, or there are more? One. The petitioner is directed to submit a representation before the secretary to the government of Assam, Department of School Education, along with the certified copy of this order, claiming for regularization, provincialization of their services. In view of the mandate of law. Acha, here his DIAS data and all are perfect. It's
That
okay.
need to be verified.
Uh-huh.
That the
That
department will verify.
verified, my lord, by that itself.
Otherwise
The-
also, if the DICE data is not there, the district scrutiny committee will not.
Would not have recommended.
Within 2 months, my lord, maybe consider.
The secretary as such is directed to dispose of the said representation if submitted within a period of 2 months from the date of
It requires 3 months, Lordship, because all the data.
Within a period of 3 months from the date of receipt of the representations, along with the certified copy of this order. The authority concerned, if finds that the case was not considered by the SLSC, may require placing of the case of the petitioner before the SLSC for scrutiny of the service particulars. Full stop. In the event the state level scrutiny committee recommends the case of the petitioner after verification of the documents, the Secretary to the Government of Assam, Department of School Education, will take further steps for provincialization of the services of the petitioner. And in case the petitioner is found not entitled to the benefits of provincialization, the Secretary to the Government of Assam would pass a speaking order in respect of the petitioner by disclosing the regions for rejection. It is not to be lost sight of the fact that DLSC had already recommended the case of the petitioner for provincialization of services, which shows that he was found eligible under the Act. And in view of the same, the entire case of the petitioner be considered.
Lords.
Petition is disposed of. Eight. Mr. Bothakur, yes, 8.
This matter relates to your lordship challenge to disciplinary proceeding, your lordship, and subsequent award of punishment by the respondent authority, your lordship.
Dismissal.
Dismissal, your lordship. My case is that, your lordship, the procedure has not been followed while
Affidavit filed by respondent number 3.
Affidavit, your lordship. We have also filed our reply.
No one is there on behalf of the respondents?
Foreign department.
Respondent number 3 is who?
The public health engineering, your lordship.
Oh, public health engineering. Who appears?
Here, your lordship, affidavit was filed by D. Gogoi.
R.R. Gogoi.
R.R.
Achha.
Gogoi.
R.R. Gogoi is not there today. Who is R.R. Gogoi? What does R.R. stands for?
From the chamber of Mr. Parangam Goswami, your lordship.
Acha, sir, from P.N. Goswami's chamber. Yes, R.R. Gogoi is present today in the court. Mr. Shantanu Bora, do you know? Have you seen him today? PHA department, there will be other standing counsel as well. So Mr. Botha could tell your junior to at least find out some, and then we can take it up.
Lords.
Hello, in this one,
So many respondents?
There are so many.
ETC.
ETC and private. Is there? They have filed affidavit. We are filing reply affidavit, which is not on the head for lawsuit. So I pay.
Not on record, your reply?
Today morning filed.
Oh, today morning. Let it be put in records, then we will take it up on a later date.
For disposal, after vacation, I pay.
Okay. Mr.
D. Gogoi.
D. Gogoi, learned counsel for the petitioner, submits that the petitioner has filed the affidavit in reply
Yes.
to the affidavit in opposition filed by the respondents,
Private respond.
private respondents, which however is not on records since he has filed it only a day back. As such, it is directed that the registry may put the affidavit in reply in records List this matter
On a hearing, there also 14.
for admission hearing on
14 July.
14th of July, 2026.
Diploma.
26.
Hmm.
The case of the petitioner is that petitioner is a retired teacher.
Retired?
Retired teacher.
Wait, she would be filing the affidavit, Ms. B. Bora. BTC.
BTC, they have filed an affidavit.
Affidavit is not there in the records. Have you filed the affidavit?
Also, they have filed the affidavit on 10/12/2025.
10/12. But then it's not in records. No affidavit in opposition has been received from BTC. That's an office note of 22 May to 2026.
But they have filed the affidavit.
They have given you a copy.
Yes, I have.
Yes,
received
Mr. Counsel, have you filed the affidavit or simply
Yes.
had given the copy?
Filed.
Huh?
File, Lordship.
But that it's not on record, you verify with the registry?
I will verify, Lordship.
Heard Mr. N.J. Gogoi, learned counsel for the petitioner, and Mr.
DC Musahari.
B.C. Mushahare, learned standing counsel for BTC. Mr. Mushahare submits that he has filed the affidavit. And that the respondent has filed the affidavit, but the
Respondent
same is
three
not
no.
on records. Filed his affidavit on,
Respond number 3. On 27/1/2.
on respond number 3, 4, and 5, he appears.
Yes, sir.
Hmm.
27/1/26.
But the same is not on records. As such, it is directed that the learned counsel may verify with the registry and place the said affidavit in records on the next date fixed.
Also, can you fix a date?
Raise this matter when?
After vacation.
Raise this matter on
Lordship, before vacation.
16th, before vacation.
Lordship.
Raise this matter on
On 16th.
19th of,
June, Lordship.
19th of, oh, what, 19th is not. 17th of June,
Lordship.
17th of June.
Please. Yes, sir.
Yes, Mr. Munir. Again, BTC? Yes.
Matter pertains to suspension, madam, prolonged suspension. The petitioner was arrested in a criminal case, madam. And subsequent to that, madam, he was arrested and therefore he was put under suspension under 6(2).
That trial is over? No.
Trial is not. And they have filed their affidavit, madam. They have stated that the petitioner, madam, can be kept under suspension till the trial is not over. But that is not the law, madam. The law says within 3 months you have to file the memorandum of charges, madam, within 3 months. And if you file the charges, you have to extend the suspension also with a reasoned order. Nothing of this sort has been done.
Yes, Ms. Counsel?
Ladyship, here in our affidavit, although we have stated about the subsistence allowance, whether the review of that suspension order was done or not, sometimes, my lord, the review is internally done and sometimes it is not communicated. And
Review
for
in
those-
extension of the suspension order.
extension of the suspension order. And whether, my lord, that those extension orders and those, I'll have to get hold of the record, your lordship, because in the affidavit, we have not stated anything about the suspension order
no.
being reviewed or.
If I may
the-
clarify, extension or review order, madam, is necessary when the memorandum of charges have been filed. And
Have not been filed.
they have, if memorandum of charges, madam, they will have to give it to me.
No, before issuance of memorandum of charges, if 3 months expires, they can extend or they cannot.
They can.
They can, my lord.
They can extend even without giving you a memo of charges.
For a moment, madam, I take.
What is that judgment which talks
Ajay
of?
Chaudhary.
Huh?
Ajay Chaudhary, ma'am.
Just show me that. But you need some further time to bring the
Yes, yes,
record.
your ladyship, because
Okay,
this
give me that
affidavit is
judgment of
not
this.
enough, your ladyship.
But till date, no memo of charges.
No, ma'am.
Till date.
Till that.
When were you placed in suspension?
I was placed under suspension on 27/3/2025.
Oh, long time back, March 25. Now it's almost more than a year.
And your ladyship, if I may submit, actually, for the respond number 4 and 5, the BTC council will be appearing. Inadvertently, your ladyship, the government council has filed an affidavit here for respond number 5 as well. That is.
Actually, that is okay, inadvertent mistake. Ajay Kumar Chaudhary.
Para 21, ma'am. Last petition. Last but one. 21. if I may read, my lord.
But here you have not given any memo of charges.
Nothing,
So how can the, even extension you cannot grant?
no.
Extension you can grant only after giving him memo of charges within that period of 3 months. So-
May give me 1 week's time, I will find it out whether the memo.
He has not
He
received.
is not received.
I have not received, and they have filed their affidavit, they're silent about it, my lord.
So this is actually
Even
not
the
done.
person prolonged suspension, more than a year, my lord, 2027, my lord.
If you issue it and he does not receive it, then there is no purpose, even if it is there in the record.
Yes, yes.
Records will not be relevant. He has not received because memo of charges is not served.
Yes, yes.
So it is not served. He did not receive. So your suspension actually becomes invalid.
Invalid.
Right. So what was done by this court? It is termed as invalid.
Here, paragraph 22, my lord. So far as the facts of the present case are concerned, the appellant has now been served with a charge sheet.
Mm.
And therefore, this direction may not be relevant to him any longer. These are the directions given for the other cases, my lord.
But now, what happened? Wait, as in the case in hand, the government is free to transfer the person concerned to any department. কি হয়?
He may be transferred to any other department so that the.
Yeah. এইটো LCB, Cotton College, Dorothy. এইটো কি মোৰ লাষ্ট অফ আপটো কিয় থাকি গ'ল? এইকেইটা মাৰিছো, কিবা আছিল নেকি কাৰেকশ্যন? মাৰি দিওঁ। 3 years of is fulfilled. No, এইকেইটা মাৰিছো যিহেতু ইয়াত কিবা কাৰেকশ্যন আছে যে আমি। LCB college will consider giving NOC so that he can appear in the interview. Review of the factors and review of the law and actually deliver. A2 আছিলে if not found আমি যে লাষ্টৰ দিনা কৈছিলো মই যে এনেকে কেপিটেল দি দিছিলো হয় দে আৰু এই ডেটটো কি দি দিছো 6th of January নহয় এইটো নহয় এইটো কি NOC এইটো সেই যে if to যে মই কেপিটেল কৰি দিছিলো হয় দে if not found ineligible should be done the petitioner directly to place the certified copy on
My lord.
Yes. Yes.
I am appearing for the.
I'm just reading that Supreme Court's order. Wait. As in the case in is free to transfer the person in any of its offices within or outside the state with no prior personal contact. Who is to survive any arrangement used for obstructing the government will also prohibit him from contacting any person who handling records. Yes, what?
Here in this case, Lordship, I am representing for the respondent number 4, 5, and 6. Here, Lordship, affidavit has been filed by the respondent number 5, that is State Council, Lordship. So for the affidavit, Lordship, I may be allowed to take further instruction. I am representing 4 and 5.
But what further instruction? He was not served with the memo of charges. So your 3-year period goes. You cannot extend. By seeing this judgment, I'm saying, if there are other judgments, we do not know.
Holding the.
There are also prior judgments, it is said here.
On the next step, maybe disposal. of-
This is being followed, ma'am.
So you have challenged the suspension order and this only suspension order, yes, right. Which has not been extended and memo of charges not given
Yes.
and your criminal case is pending. That is okay, that is different. You will pass suspension order again, but this suspension order will go.
Yes.
Our affidavit is required, Lordship. Affidavit, although affidavit filed by the respondent of 5, Lordship, but this is the.
It's been.
Where is the suspension order?
No.
Order is
suspension-
not there.
It's 6-2, my lord.
Suspend.
Deemed suspension, ma'am.
Where is that?
Still, let us confirm.
6-2, deemed suspension.
Under Rule 6.2,
6.2.
FRSR or what?
No, Assam Service Discipline.
Acha. But you have not annexed, you want to cancel this and without the order?
There is 6.2 provision, deemed suspension. If someone person is arrested, madam, he will automatically be suspended.
No, in that case, this case will not come.
No, it has been upheld, in a division bench judgment, madam.
Huh. Reinstate the petitioner in service and release
Paragraph 15, madam.
your prayer, deem suspension.
Yes, suspended under 6.2. Paragraph 15. This confusion was raised in a single bench, madam, then it went to in reference.
Acha. So this is a division bench order?
Division bench.
Acha. Acha, deem suspension is also included.
And the period, my lord.
But here, that memo of charges has to be given within the 3 months period, whether that will be applicable.
Yes.
Because you see in the subpara of paragraph 13, it is said that it is left to the department to make periodic review within the period of 3 months and decide as to such a suspension order is required to be extended or not.
That is
So periodic review by assigning regions or not by assigning regions. So periodic review within a period of 3 months, but requirement of giving you the memo of charges is actually not written here.
that is from the Ajay Chaudhary, madam.
Ajay Chaudhary, but here it is said,
Ajay Chaudhary, my lord, that was pending departmental proceeding. And the confusion is came up, my lord.
whether deemed will be included,
Yes.
but they said that deemed will be included.
Covered the deemed suspension also. And the period from which it has to be counted, my lord, it has to be from the date of arrest. That also, my lord, our this court has settled, my lord.
Your subsistence allowance thing will come later, but first of all, his deemed suspension is wrong. Since it is there for so many months.
Prolonged suspension.
More than a year.
Yes, more than a year.
It has to be counted from the date of arrest.
So his
Paragraph 20.
suspension order will go. If we apply Ajay Chaudhary. And then you take further action. But then this deemed suspension will go. Right. What have they stated in the affidavit?
They have said that they can keep the person suspended till the disposal of the criminal case.
That cannot be
Your
the.
ladyship, the
No.
board will take the decision of reinstatement, so let him have his instructions.
It is for the BTC to take, to reinstate you.
No, the person who have filed the affidavit, he is the executive. He is the executive officer of the municipality board, ma'am.
Exclusively BTC lordship, our
Respond number 5 is wrongly written, you said, right? He is what? He is
Wrongly written.
executive officer. He is the executive officer, Fakiragam Municipal Board.
This is the board where the person was working as a junior engineer. He has stated, my lord, that to come to.
This is respond number 5. Respond number 5, Fakiragram Municipal Board. So BTC is where?
4, 5, and 6. Respondent number 4, 5, and 6.
Is it?
No.
Your Secretary Urban Development, BTC
appearing-
Kokrajhar. 6,
I'm appearing.
okay. 4 and 5 you are appearing.
I'm-
BTC authorities. 4 and 5?
4, 5, and 6.
Four is appearing, my lord. My lord will kindly see order dated 33/2026. First in this case.
13-3.
33,
33. Yes.
30/03/2026.
Service is complete in respect of respond number 4. Respond number 5 is represented by State Council, 6 is yes, 5 is actually State Council. 5, Executive Officer Fakiragram Municipal Board. I think Government Advocate can appear.
Yes.
BTC only
have
for
taken-
6,
I have taken instructions just. to-
but BTC only for 6.
Entire exercise will be done by the
Yeah.
BTC lottery.
The subsistence allowance that has been given to him, that part is taken. But as regards the review of his suspension order or not serving in the memorandum of charges, that part is not even there even in the parawise comments. So that is why Lordship can pray for a week's time for the.
Now, my lord will kindly see whether suspension is illegal or a prolonged suspension.
No,
is
let
legal.
us be clear with the respondents. State of Assam, this is Urban Affairs, Government Advocate,
Maybe due to
Municipal
some
Administration. But he cannot appear for 4 and 5. You cannot appear for 4 and 5.
4 is not appearing.
Municipal is our department, that is why.
Hmm?
I just
He will appear for 6. respondent.
6
have
only.
taken telephonic
Secretary Urban Development, BTC. So you are only for 6. 4 and 5, Government Advocate. And the order and the affidavit is filed by Executive Officer Fakiragram Municipal Board, District Kokrajhar. Hmm?
Maybe due to some miscommunication, they have filed their.
Miscommunication, my lord, this person should not suffer. He has been suffering for more than a year, my lord.
Supposed to file by the BTC council, by the,
Assumptions,
but
presumptions,
filed by the
reflections.
state council lordship. That is why I may be allowed to.
This order cannot sustain.
I see office note, none appears for respond number 4. Although service is complete. You did not appear that time.
Last occasion, maybe due to some miscommunication, our council may not record his name.
The question is.
But what I'm not convinced is whether Ajay Chaudhary will be applicable. Okay, it will be applicable in deemed suspension, but whether for non-supply of this memorandum of charges within the 3 months.
Rakibuddin says
Hmm.
Ajay Chaudhary will be applicable also in case of 6-2 deemed suspension.
yes.
Now, Ajay Chaudhary says you have to file the charge sheet within 3 months. That has not been done. And if you file the charge sheet, you will also have to extend. If you want to extend, then there has to be a reasoned order. We're not going into it. The first thing is that you have to, memo charges have to be served. That is not served much.
Reply nahi diya. कुछ reply दिया ना. ये तो करते हैं.
Your Ladyship, we have stated in our affidavit at page 42, annexure 2, that a show cause notice was issued to him.
Also,
And,
when?
later,
These are other case.
on 6th of April 2024,
Other case.
Where? Page number?
Next warning.
42.
In respect of some other case?
Other
42.
case that is culminated.
Page 42 you are saying?
Yes, Your Lady. And at page 43 is a warning letter.
That is how it culminated.
So this is a show cause notice you are saying in some other case.
Other case, madam. He was arrested, my lord, on 27/3/2025.
Oh, this is on 23 case some. See? This is 2023 and this letter is by 2024. Okay, heard Mr. P.K. Muni, learned counsel for the petitioner. And I'm disposing of this matter since he has not received any. And Miss, yes, your name please, Miss, I forgot.
No, Sharma.
U. Sharma, learned standing counsel for learned government advocate. Learned government advocate for the state of Assam and
My
Mr.
May I submit one thing, Lordship? Entire exercise will be done by the BTC, Lordship, reinstatement and all.
How, but then the
But
fact remains.
Our instruction is that, my lord, supposed to today, Lordship, Mayor John, Lordship.
You have not
On the
filed
next
for
date, maybe
affidavit.
dispose of, Lordship.
Hmm?
On the next date, I will take instruction.
Not
Lordship.
file affidavit, but the fact remains it is illegal. Ajay Chaudhary, you say why it will not be applicable, Ajay Chaudhary?
Ajay Chaudhary, I will, whether it is reviewed or not, that is.
Reviewed only after you give him the memo of charges. Memo of charges he has not received.
Regarding all these things, I will take instruction. Lordship. All these things.
Arey, he has not got. So what instruction? It has to be served upon him. It's not that it is to be issued. It has to be served and he has not got.
What's it?
Mister, you tell your name? Mister?
DC Musafir.
Shari for BTC. By this application, the petitioner by this application filed under Article 226 of the Constitution of India, the petitioner has prayed for a writ in the nature of mandamus. Has prayed for setting aside his deemed suspension passed purportedly under Rule 6(2) of the Assam Service Discipline and Appeal Rules 1964. Pursuant to his arrest on 27/3/2025 in connection with ACB police station case number. Yes, Mr. Kumar, you are sitting for 31.
This case has been subsequently again clarified in the 2023 Act. This 90 days window period will not run from the date of arrest because when a person is in custody, the memo of charges cannot be served. So this 90 days period will be start on the date of this week. Even otherwise.
No, that has changed, sir.
I think there's a vision there.
So 90 days period is changed.
Counted from the release, so deemed suspension will automatically lapse after 90 days, because after 90 days, they cannot give a rest release of time. Earlier, it was not the release of the data, whereas now it's data subject to fact by this is of 2025. Maybe I don't know, they are conflicting just.
So he has been released, right?
We also submitted a presentation.
If the 90 days will, it's over, then the suspension will also lapse, because after that, whether they pass any review committee or order or not, that doesn't.
That will not matter.
I think it is.
That is why I'm thinking to dispose of the matter. Why wait for the affidavit?
This, give a new lease of time. to this.
Okay. Oh, yes, you come back at 31. I'll take that matter as the first one. ACB PS case. ACB PS case number 29 of 25. Registered under section 7 within bracket small a of the Prevention of Corruption Act 1988. The petitioner has also prayed for a direction to the respondent authorities to release the unpaid subsistence allowance due to the petitioner since the date of his deemed suspension.
He has been paid till November 2025. They have stated in their affidavit also.
Okay, I'm just restating the prayers. As well as with the prayer to reinstate the petitioner in service and release all consequential benefits. It is the case of the petitioner that while he was working as what?
Junior engineer.
Where do I get? Acha, while he was working as an
Page 16, madam, his regularization order, madam, page 16, annexed.
page
16, 1/6. That is the regularization order.
while he was working as a junior engineer on honorary basis. Oh, no, no. While he was working as a regularization, was junior engineer under the Fakiragram Municipal Board. He was arrested when? He was arrested on 26/3/2025 in connection with the above mentioned case. And that he was placed and due to the said arrest, he was placed in deemed suspension by the office of the Fakiragram, right? He was placed under deemed suspension by the Fakiragram Municipal, by the authorities in the Fakiragram Municipal Board. It is the further case of the petitioner that he was arrested on 27/3/2025 and that he was released on release nahi, he was bailed or what?
Bail order, my lord, page
Haan.
24, madam.
He was bailed out on
24/4/2025.
page.
Page 24.
He was bailed out on 24/4/2025. The learned counsel for the petitioner submits that the petitioner was put under deemed suspension on 27/3/2025 on the date of his arrest under section 6(2) of the disciplinary appeal rules. That is by the mandate of law. But the further mandate of law has not been followed by the authorities concerned. He submits that it is required under the law that within 3 months of the suspension, the petitioner should be given the memo of charges / charge sheet. And if it is not served upon him within the 3 months period, the suspension order gets ineffective. He further submits that on service of the memorandum of charges within the said 3 months period, if given, the authorities may extend the period of suspension by another period, but with a speaking order. He has placed reliance on the judgment of, where is that main judgment?
Ajay Chaudhary, madam,
Ajay Chaudhary.
2015-7.
You had given, right? I had read. Main reliance on. You had given. Oh, yes, yes. Place reliance on the judgment delivered by the Honorable Apex Court in Ajay Kumar Chaudhary versus Union of India, reported in 2015-7 SCC 291, by which the Honorable Apex Court had held that currency of a suspension order should not extend beyond 3 months if within the said period, memorandum of charges / charge sheet is not served upon the delinquent officer employee. And if the memorandum of charges is served, a reasoned order must be passed for extension of the suspension. Para. Although in the set, oh no, he has placed reliance, right? He has also placed reliance on the judgment of which one?
Rakibuddin one.
Of this honorable court, delivered in Rakibuddin Ahmed versus State of Assam.
Is reported in 2019.
Reported in 2019 5 GLT
600.
600, wherein it is held that although in Ajay Chaudhary's case, the suspension order was passed in contemplation of issuing the memorandum of charges, the same is applicable even in cases of deemed suspension made under rule 6.2 of the discipline 1964 rules. 1964 rules. On the other hand, Ms. U. Sharma, learned government advocate, had placed the affidavit in opposition submitted by the government, respond number 5, wherein it is reflected what? Reflected that
That he has been paid the subsistence allowance along with other arrear to the tune of 3,36,000.
that here the petitioner was paid the subsistence allowance to the tune of rupees 3,36,500 along with the arrear. Matlab arrear for all these months you have paid,
After
right?
his
50%.
suspension. After his suspension, all relevant documents are also enclosed in one slip.
For all the কি বুলি ক'লো? Including all the including the oh no, how about till date, right? I mean till
November 2020.
Till November
2025. Nothing on this suspension 3 months, nothing.
Silent. They are saying that until unless the criminal case gets over, he can be kept under suspension.
Where is that?
Yes.
It is further stated in the affidavit. Page
32.
Para 8.
Para 8.
Acha.
More effectively said in paragraph 9, my lord.
It is further stated that the petitioner be kept under suspension till the criminal case registered against him gets concluded in the trial. Para. It is, however, a settled position of law that a delinquent, that an employee can be placed under suspension and a said suspension can be placed under suspension on being arrested in connection with any criminal case. And a said provision is provided for under Rule 6.2 of the 1964 rules. But at the same time, it is also settled position. It is provided that a employee can be placed under suspension under 6.2, right? On being arrested, right? It is a settled position of law that the suspension order made for a period of 3 months can be extended only after serving the memo of charges / charge sheet on the served, right? Served question on the employee within the said period of 3 months. And if it is not served, the said suspension order gets ineffective. Further, it is decided by the under the law. Further, it is decided by the apex court that if memo of charges are given within the period of said 3 months of suspension period, the said suspension order can be extended after regions being ascribed by the authorities. In the instant case, it is seen that the petitioner was placed under deemed suspension in the month of March 2025. Until date, he has not been served with any memo of charges / charge sheet by the authorities concerned. And as such, by virtue of the law laid down by the Honorable Apex Court, the said suspension order gets invalidated, gets ineffective.
Just say suspension, there is no order.
Said suspension or no order, yes, deemed suspension. Said suspension gets ineffective. Order nahi likhwa. Further, it is also held that the 3 months period cannot be reckoned from the date of arrest, since memo of charges cannot be served upon the petitioner while in jail.
This gray area, my lord.
Gray area.
Because there is a, this came up before Honorable Justice Devashish Borua. So there it was, he.
But it's a fact. Now, how can one go and how will he file reply?
That is other judgment, but recent judgment, madam. I have already submitted, madam.
It is submitted by the petitioner. That cannot be from the date of arrest, but from the date of his bail or his release. In the instant case, the petitioner has been bailed out. Doesn't matter. Has been bailed out when? Bailed out in the month of April 2025.
Right.
Even after, if 3 months period is reckoned from the date of his bail, the same is over much before, much earlier, and that he has not been served with any memo of charges. In fact, no memo of charges has been given to him till date. As such, the deemed suspension has become ineffective. Accordingly, okay, if some changes, I'll make it.
You have to be reinstated and.
Yes, accordingly. But in case in between, I have to put something else. See, accordingly, the prayer of the petitioner is allowed. The authorities in the BTC department, no, the authorities of Fakiragram, what?
Fakiragram Municipal Board.
The authorities in the Fakiragram Municipal Board is directed to reinstate the petitioner in service forthwith. Petition is disposed of. I'll think over. And give all salary.
Proceedings allowance, madam, from November 2025 to till date.
And allow him the financial benefits accustomed with his service. It is further directed that the authorities may also pay him the remaining subsistence allowance from November 2025 till the date of his reinstatement. Petition is disposed of.
I'm appearing for the respondent number 6 then.
I've already written your name. Here, take back your judgments. Judgment like one. Okay, if you take it later.
Don't need.
Authority of BTC and judgment of division bench, so I need my lord any day next week.
Okay.
I am prepared, Lordship.
Otherwise, she is with the judgments.
For Lordship perusal.
Acha, give me those judgments and just tell me.
The Boardmaster Lordship, I am giving.
You have given the.
No, I shall give the hard copies. I just asked to bring this.
No, before those hard copies come, you just tell me the ratios in those judgments.
No, ratios are Lordship because of this time lapse.
This is the main thing, Lordship. Devabrata Tiwari, this also I have got the printout, Lordship, because this is the basis of all judgment. This long delay. This cannot, because
But
this is.
cannot be applicable in all facts and
Yes,
circumstances.
in all the facts. And based on this, the notification has been issued by the state of Assam. And this has been upheld, Lordship, everywhere. And accordingly, all the pending cases are being disposed.
But delay for no fault of the petitioner then?
No, Lordship. Here, 2001. 2001, admittedly, case filed in 2002, then in 2023.
No, in between he tried.
In between, whatever, because have they shown what is these things? What are the correspondences? Mere writing of the these correspondences and all these things, this does not, that means, entail any right upon the petitioner, Lordship.
But then,
There are so many, even Lordship, the recommended, SLC recommended, this has also not been entertained by the.
I am concerned only BTC, my lord, empowerment of the BTC. Other judgment, whatever she is planning to rely upon, that is relating to other places. I am concerned only with the BTC.
No, what will be the difference there?
No, my lord, BTC district level committee was constituted only in 2015, my lord. What is my fault? Can I say, my lord, you organize committee or this thing? It is because of the authority, my lord, BTC. They referred the matter lately.
In between, you had no other.
I have the communication, my lord. All they made a communication. They asked for the documents.
Now, why you want the matter to get deferred?
Deferred, my lord. That schedule part, my lord. If your lordship is otherwise not, they are not onto that, my lord, then lordship can hear.
No, the BTC council is here. You want to what?
Yes, yes. BTC, they are the having power, my lord. In persons to the, my lord, special enactment was made, my lord, 6th schedule during BLT, my lord. They made one agreement with the state of Assam plus government of India that grade 3, grade 4, excluding police, they are the one authority.
They are the authority.
They
But
are
of
the-
course, they'll have to follow the rules. DLC has
They
to.
are following, man. They are following them. Because here, my lord, DLC has recommended my case.
SLC said
my lord,
late.
interpretation, wrong interpretation, rejected my
Yes.
case.
That so delay you had survived.
I have not, my lord. Delay is not on my part. It is by the
Yes.
authority.
But then in between 2002, when did the judgment was delivered? Acha, am I taking up for final disposal or Mr. Barbia, you want some time?
My lord, and otherwise also, I got one part of matter in court number 4.
Acha, acha.
That is I'm worried someone. If it does not take time, my lord, I can argue with it.
Okay, you come little late then. I'll take it up after some time.
Little late, my
After
lord, I'll
finishing?
start it right now, my lord, as far as possible. Or lordship fix the matter, any other thing. If it is
Otherwise,
fixed-
she is ready with the cases.
Cases
She
will
is
move
fresh in her
to
mind.
judge.
Huh?
I brought it up. Division bench say. But if peculiar facts and
It
circumstances.
is up to you, up to both of you, whether you want to do it, I can hear it, or you want to do it little later.
No, no, kitab to anna nahi, na move on. See. To dekhai this. Notification.
Okay, you start. Let's see.
My lord, here, my lord, what happened?
My lord, regarding notification, let him bring on record, lordship.
It is there, it is there.
Let
It is there.
bring on record.
It's annex kora আছে।
Annex করা।
হয়তো annex করা নাই।
I've already seen the matter, why SLC and all. So I just wanted,
SLC rejected, lord.
I just wanted the judgments by Miss M. Bhattacharya.
Before
Okay, you can place the judgments.
judgment, I'll come, my lord, one division bench, state of Assam preferred one appeal. There, my lord, there is a 2 judgment, my lord. One is by Justice Michael. He said, my lord, that is WBC 4342/25.
Okay, send me that.
I'll just give it to my lord. It's a marked copy, my lord, my office copy. And another judgment, my lord, of our division bench. Division bench, my lord, read appeal 287/23.
So this Justice Michael judgment, which paragraph?
Last paragraph, last page. my lord.
Paragraph 9 and 10.
Last-
Devabrata Tiwari was,
Yes, my lord, it has been held up to April 2017, the case can be. closed. And my case is earlier to that. ওলাব লাগিব আকৌ, ন? নাই।
this decision speaks of that after it has been abolished, compassionate appointment. After that, it will not, Devabrata
Yes,
Tiwari will not. But here is not a case of post
Abolition.
2025.
Division bench also same line, my lord, because
Ah.
they cancel it and division bench said, my lord, some facts, special facts and circumstances will leave the case. ma'am.
Judgment. 12/12/25.
It was this, yeah.
Your case is simple. DLC has recommended your name.
SLC has.
SLC has refused, saying that so many years have elapsed.
Ma'am,
Right.
That is.
And they could survive through all these years,
all
and so
these
there is
years,
no
whether
necessity.
This years is, it is on my part or on part of the government.
Uh-huh.
Because I
That
have
is
the
all.
next, Lordship will see one document, my lord,
Hmm.
when the DLC was constituted, my lord.
Hmm. Which document?
This Lordship, the judgment, my lord. Copy of the communication, Lordship, page 33.
Hmm.
33, my lord says,
So the BTC says that BTC had constituted BTC level committee
yes, my lord. Page
for
33
appointment of
says,
compassionate. Then,
committee, it has been intimated February to 15.
hmm.
Thereafter, my lord, they made inquiries, page 35.
Hmm.
They made a query and page 35 with refers to, sir, I have the honor to inform you that 29 number, the post, my lord, that is not disputed. Thereafter, my lord,
But non-availability of vacancies.
my lord,
This was in 21.
yes, my lord, non-available of the vacancy judgment said, I approached to the Honorable High Court.
Hmm.
Then, my lord, in a case of other department also can be considered. So accordingly, BTC considered my case.
Hmm.
Page 38, my lord. The London Council, some the application was only forwarded to the additional Chirang Principal Secretary before, in spite of Director BTC to consider the case, my lord. Thereafter, my case was considered. Page 40, para 9, my lord. Accordingly, this court is of the interest of justice. Is our present petition closed with the direction to the respondent, more particularly DLC, to consider the case of the in terms of office memorandum, pass appropriate orders. This exercise shall be carried out. And so this also I was hesitating. Thereafter, my lord,
This was which year, this judgment?
this judgment was, my lord, delivered by this honorable court. I filed case
23.
23. 9/8/23.
So this case was filed in 23 itself.
23 itself. Because,
But something you showed me 2017, there was some exercise.
yes, I did there, my lord. In the document itself will reveal. Then they made in
So then DLC.
DLC, my lord. Before that, my lord, DLC made in quarries.
Hmm.
Based 54, my lord.
Hmm.
Or 53 and 54.
Hmm.
With reference to the subject, I have the honor to submit here with the copy of the minutes. Minutes was only referred, my lord, 18 December 23.
No, 20th December.
Yes, my 18 December, page
Huh.
53, my lord.
Okay, that letter was of 18 December
18 December.
23,
Yes, my lord.
but the DLC meeting was on 20th of September.
Yes, my lord. Then it was referred to the authority, my lord.
Hmm.
23.
Hmm.
Thereafter, my lord, again they wrote a letter at page 54. My name appeared at serial number 5.
Hmm.
Inviting to your letter, I am to submit here with the required documents, that certificate, everything. Thereafter, another, my lord, communication was made 24, page 55. Submission of the information, vacancy position, everything, my. page 55. Which ultimately was provided vacancy position, my lord,
Hmm.
annexure 18, page 59. My
Page
all status,
29,
page 59,
59.
my lord.
Yes.
The vacancy position also given, man in position, and what I am entitled, how much salary. pension.
Where vacancy position? Yes, vacant
Yes.
position as on so and so. Junior assistant 1 is vacant.
My lord, vacancy is there, my
Grade 4 is 6.
checks.
You are supposed to be in what post? Grade 4.
Get 3, because I'm graduate.
But
Then
this is in
also,
respect of grade 4.
my grade 3 and
Page 59.
page 59.
Grade 3
is
and 4, yes.
Vacancy position of the junior assistant 16.
Mm.
2 numbers of Srimati so and so, they are men in position. Next column,
Vijay Deka.
my lord. Thereafter, my lord, at page 60, BTC has referred the matter from agriculture HOD. May I read, my lord? In inviting on letter number reference, I am to forward here with the required documents as sought for by letter dated in respect of 8 numbers of recommended candidates for the appointment compassionate ground from CSD. CSD is the chief head of department of forest department, agriculture, CSD, handloom, and so BTC. This favorable. Then, my lord, SLC.
This
has
includes the
reject-
petitioner, 8.
8 years, my name is there. Because
And the
I'm,
minutes of the state level.
my lord, then, my lord, minutes of the state level, though they have reflected, my lord.
That I
my-
have seen.
Then
Yes,
rejected because only reason, SLC rejected because of long years.
Mm.
And there is no my fault, my lord. I was hesitating all along. 2015, they have constituted,
Yes.
and they are making one after another queries.
No, you showed something where 2017 some action was taken by the applicant. Hmm?
Copy of the letter, page 34.
Okay, I've seen your case. Ms. Bhattacharya, just show me those judgments.
Judgments of our court.
Hmm.
That means on the long ground of delay and the main case, the basis of which Devabrata Tiwari law. And I have flag marked one para losses especially.
Let me see Devabrata Tiwari first. What is the paragraph here? 35.
35, more particularly, just request lordship to vote. Delay part lordship.
May not be entertained
Lordship.
since the date of the violation of delay.
Delay may
Okay.
be on either side, Lord.
Mm,
Either
yes.
side of the petitioner or the respondents also, Lord. So this,
It again depends on facts,
Facts.
whether the,
Be applicable.
no, the
Facts
last
is-
line is may not be entertained after lapse of a considerable
Yes,
period.
yes.
So may not
The
be.
facts of the case, it is not similar with me.
Okay, the other two judgments, the,
Others given, my lord.
no, by her, huh?
yes, Lordship.
Bachu Das, paragraph?
Yes, but, 501/2023.
Huh.
Regarding, this was actually, I think, the petitioner counsel, he also wants to show this regarding the striking out of clause 1, the remaining period of service. On this case is their lordship. Here paragraph 6 and 7 may kind
So the clause 1 was it was struck
No,
off.
it has been taken care of by the division bench.
Ah.
And on the basis of this, because here also same thing,
Hmm.
paragraph 6 and 7 that I want to refer, Lord.
6 and 7 of single judge's order.
Yes, Lord. No. This is separate. After passing of the division bench order, Lordship, the
Acha.
compassionate appointments which are before the single bench's Lordship. So this case has been heard and accordingly it has been disposed, Lordship. And this
So,
has not been entertained.
on the consideration that clause 1 is no longer there.
Even if it is not there, Lordship, even if it is not there, but the long delay part.
So where is the delay? Which paragraph?
Paragraph 6 and 7, Lord.
6 is a quotation. So it is Debabrata Tiwari.
Yes,
Then
Lord.
7.
7, this has not been taken care of by law.
Okay. What about the other case?
It's it,
Ram Krishna, yes.
Lordship. Here, the fact of the case is almost similar to that of the petitioner, Lordship, paragraph 5.
Hmm.
6 also, the court has observed something, Lordship, and para 9. This is important, Lordship.
Okay, 5 I have read. What are the other paragraphs?
9, Lord, 5, 6, Lordship. It's a small paragraph, Lordship. 6, also some observation has been made, Lordship. And paragraph 9, Lordship.
But that is less than 3 years. Then 9.
Yes.
Okay, this is again Debabrata Tiwari.
Because everything has been on the Debabrata Tiwari Lordship. Because the notification by the Assam government is also on this Lordship, on the basis of Debabrata Tiwari.
So, Mr. Barbia, what I can see is, of course, over these years, you have sustained yourself. Maybe you have got some other venture.
The new notification came out in 2015, man. My case was to be considered earlier to that.
What
That
earlier?
notification was there most probably 1983, man.
What notification?
For
OM.
compassionate appointment. The 15 they are relying, or I have shown yesterday also 15. Prior to that, it has to. There is a judgment, my lord, at the
I
time.
forgot that 15 notification. What was the issue there? What was the
15 notification he
15
cannot deny because the honorable court has directed to, that means to consider his case on the basis of 15 notification, Lordship. So how he can go back without this notification, Lordship? Because this is the 2023 order is on the basis of this, Lordship. And accordingly, where the district level.
No,
committee
just
has-
show me the notification again. I
Yes,
forgot
yes,
that
I-
relevant part. You have shown in some
Yes.
petition copy.
There are eight. I have marked it all. Only applicability of the, my lord, delay and laches is on my part or Debabrata case is applicable in the instant case that your lordship are to examine. Otherwise, it
What
has.
was that? And this 8, yes,
Mine.
8 I was seeing yesterday.
Yes.
Yes. So what do you want to show it from here?
Yeah, my lord, in persons to the BTC, my lord, BTC as the authority, they have accordingly recommended my case placed before the meeting.
Yes, DLC was constituted, you have shown somewhere
Yeah, ma'am.
by the
By
BTC authorities.
15, my lord.
Then,
Then, my lord, they have examined and they have examined my case, my lord.
DLC has recommended,
DLC recommended, SLC, my lord,
rejected. That I have
rejected
seen.
only.
Yes, but what about the delay part as said in
Delay
the
is
Dev-
not on my part.
No, in Devabrata said even if it is on your part, even if it is on the part of the authority, if there is delay.
Facts and my case of facts may be something different.
No, that is, facts will always be different in respect of cases, but then,
Be applicable or not, my lord, that your lordship.
but then 35 is general to be applied in all cases. Right.
36.
What is the final finding conclusion in this case, Ms. Bhattacharya? Rejected
Lordship, which one?
in Devabrata.
Debabrata, yes, Lordship. It was filed by the state of West Bengal, Lord.
Forty-seven, my lord, says something different.
47 of Devabrata.
Yes, ma'am.
What
But
does
I
it
doubt,
say?
my lord, it is.
I have seen 35.
Yes, 35, 36 also, my lord, let's just undue delay, that is relating the total, my lord, 47 be seen, my lord. However, we are of the sound song of the reapproach directed the authorities of the appellant state about the manner in which the application for completion or appointment handles of the dependents have been dealt with. Much uncertainty loom on the scope of the extent beneficiaries of the various schemes formulated by the state for governing. Therefore, the authorities concerned are unable to and willing to positively decide the claim of the completion appointment. This may have ultimately resulted in prejudice to the families of many government employees in dying in harness. Delay on the part of the authorities of the state to decide the claim of the completion appointment would be no doubt frustrate the very object of the scheme of the appointment. The
But Ms.
government
Bhattacharya,
officials-
what I'm thinking of is, okay, there is a delay, right? There is a delay of so many years. But again, Supreme Court has not said that in each and every case, wherever there is delay, you reject. That is not the case here. So here, let the SLC see the other facts, how they are able to sustain, what is the financial condition of the family.
Lordship, this is clear in the OM itself, Lordship, and this is.
Have they looked into that?
SLC, Lordship.
No, have they looked into that?
SLC has not looked into.
No, see the rejection order.
The rejection.
Page
Ah.
63 and 64.
Huh. The SLC noted that.
Noted that.
Yes. Yes, I've seen.
The SLC noted that the complaint employee had expired on 15 to 2001. That is more than 23 years ago. The objective of compassionate appointments is to provide the bereaved family with immediate financial assistance to cope up with the situation. It is an accepted norm that in case several years have passed after the death of a government employee, it would appear on the face of it that the family has managed to support itself all these years and has some means of subsistence. And in such case, compassionate appointment are not ordinarily to be given. In the instant case, the DLC has not recorded any ground for recommendation and in particular has not made up a case to justify requirement of compassionate appointment after over 23 years of the death of.
So the DLC has not gone into. But let DLC go into whether they are still.
Regarding this lordship, why it is needed, this has not been. Generally, they have, that means sustained after the death of the
No,
government.
sustenance is okay. But then whether in a.
Any averments there, how they sustain it. This is nothing is there, lordship.
So they will not say that we have been getting money from other sources. But then it is for the DLC to examine all the documents, all the what? They have to be asked to show documents. How did they survive?
In never-ending process, lordship.
At least some prima facie thing has to be seen.
And there are other cases, lordship, where not only DLC, SLC recommendations were also there.
And the rejection by the SLC is not only on delay. They have also said that DLC has not examined properly.
Yes, this is true. But this also has that over the years, the 23 years has done by lordship.
That is seen.
And the petitioner has sustained over the years.
Sustained, they will not die out of hunger. They have sustained. But then in what way? Whether somebody is,
Then the commission has to be lordship, that means required to be
No.
honored, because they will look into how they have sustained and all these things. lordship.
something has to
That is
be,
no way out other than this lordship.
simply leaving it to delay will not be fair. Okay, let DLC again examine their case and give a detailed report.
Lordship,
There is
What?
no DLC, no SLC right now, because all has been
Banned, abandoned.
Yes, lordship. After the passing of this,
25.
yes, 25 notification, there was an, Abdul Kadir Bakshi, no? This case was.
But
there.
for earlier cases, they have to say.
Yes,
No,
yes,
all-
earlier case, all
Earlier
cases.
cases are also being taken up on the basis of the Babraktivar. Because this
Retrospective,
has, the
prospective
principle has
cannot be.
been set lordship, and this has been, and presently lordship, all the cases, because after this passing of the order by the single bench, honorable single bench lordship, the notification and there was applications were called, whose cases were pending. So each and every case has been taken care of, DLC set, SLC set, everything was there, lordship.
Okay, heard
So this
Mr.
was one measure, and that's why this has already been taken finally, lordship.
Okay, heard Mr. J.I. Bormia, learned counsel for the petitioner, and Ms. M. Bhattacharjee, the additional senior government advocate, and Mr.
BC Musahari.
B.C. Musahari for respondent number. The standing counsel for BTC representing respondents number
2, 3, and Lordship.
2, 3, and
4,
2, 3, 4.
4,
All
Or
BTC
six.
authority will do.
6, 7,
BTC authorities, it's okay.
8, and 9.
BTC, yes. Respond number 1, Miss. Yes, Miss R. Borua, learned counsel for respond number 1. Bora. By this application filed under 226 of the Constitution. Mr. Chaudhary, you are waiting for some matter. You can come little late then. I'll just dictate this order. This will take, I think, 10, 15 minutes. Then I'll take up Mr. Kumar's matter. He is sitting. Okay. Heard Mr. Oh, yes, they hit a hole. By this application filed under Article 226 of the Constitution of India, the petitioner has prayed for compassionate appointment for his compassionate appointment to the post of to the grade 3 post under
My lord.
to the grade 3 post in what department, in what Harry? Grade 3 post in the
Agriculture department.
in the agriculture department
I'm
of
sharing one more judgment of the division bench, lordship. I'm just taking case of.
yes
Judgment.
yes I'll come to
Okay, same.
under the agricultural department.
Kindly record my submission, Lordship. Whatever my learned senior friend stated about the 6th schedule area, this is what my learned friend is already DLC forwarded, recommended, and committee constituted as per the
Law.
as per the law, as per the procedure, Lordship, as per the office memorandum, Lordship.
I'm not
But-
disputing that. I'm not disputing.
And Lordship, DLC already recommended. That is why SLC rejected. And
That is
whatever
known.
recommendation, then maybe look into Lordship.
No, that is known. We have seen. What else?
As per Honorable High Court order, we complied it accordingly. Lordship.
Yes. Yeah, okay. The petitioner has also challenged the order dated, no, the decision of the SLC,
DLC.
the decision of the SLC dated 31/8/2024, by which the proposal regarding recommendation of the district level selection committee
Selection committee,
dated 29/2023
23.
was rejected. So many prayers, I think that will be all. It is the case of the petitioner. that his father was working as peon in the office of subdivisional agriculture officer, or in the office of subdivisional agriculture officer Bijni, and that he expired while in service on 15/12/2001. Full stop. It is the further case of the petitioner that after the death of his father, the petitioner submitted an application on 18/1/2002 in the proper format before the district agricultural officer, Bongaigaon, praying for his appointment on compassionate ground. The petitioner further states that on 11/6/2002, the district agriculture officer, Bongaigaon, forwarded his application to the Director of Agriculture, Assam, Khanapara, for the disposal. However, on not getting any response from the respondent authorities, the petitioner filed a writ petition being WPC number 6592 of 2002 before this court, and this court by the order dated 8/10/2002. Where is that order, Mr. Barbia?
Not true, my lord. This order is
8/2/2002. That was ordered by, I've seen yesterday. So, Saikya?
page 37, my lord. 8/9/23.
9/8.
Oh, yes, sorry, 9.
9/8/23. No. What is this 8/10/2002?
To the first case.
That was by.
That your lordship will see at page
6592. Oh, yes.
29.
So and so, by the order dated so and so, directed the respondent authorities to consider the case of the petitioner for appointment on compassionate ground within a stipulated time, with the further direction that the authorities will consider the claim in terms of the eligibility and in light of the policy in force. Full stop. In pursuance to the said order, what happened after that? This is 24.
My lord, no DLC was not there, my lord. Only page 33, the DLC was constituted.
Pursuant to that order, it is stated by the petitioner that the district level selection committee, scrutiny or what? Selection committee. Selection committee was not there at that juncture, and that by 11th of February 2015.
15, there is no DLC.
15. The BTC had constituted the BTC level committee again.
My lord.
Constituted BTC level committee.
Not BTC level committee, lordship.
This is what?
District level selection committee.
It is B or D?
B. It's 33, sir. BTC level committee.
BTC level committee for appointment on compassionate grounds. To look into D. Or what? Not to look into. For appointment on compassionate grounds.
Thereafter, page 35. Thereafter, my lord, they initiated process, page 35.
Thereafter,
Page 35.
the vacancy position was also
Yes.
sought for by the authorities concerned, and the same was intimated by the Subdivisional Agriculture Officer, Bijni. However, the petitioner did not get any response from the respondent authorities regarding consideration of his case for compassionate appointment, and had approached before the authority to know the status of his case. Full stop. In pursuant to such request, the petitioner was apprised that his case was forwarded to the Principal Secretary BTC for consideration by the BTC level committee. The petitioner further states that after the disposal of the aforesaid writ petition in the year 2002, the petitioner had on many occasions approached the respondent authorities to consider the case for appointment on compassionate grounds, but the petitioner was not communicated about the same. Aggrieved thereby, the petitioner had filed another writ petition before this court, which was registered as 4507 of 23. And this court, by order dated 9/8/2023, had observed that the matter regarding appointment of the petitioner and similarly situated persons on compassionate appointment was processed and considered at different levels by different offices for last several years, and that ultimately by a communication dated 17/11/2021, it was informed to the petitioner that his case was not forwarded on the ground of lack of vacancies. You want to go to other court?
No, my lord. Alas.
Acha, acha.
And there is another judgment he has delivered yesterday. Even compassionate appointment married daughter is also considered. It is not the fact, my lord, by virtue of Devabrata, all cases gone. It is not.
And
I'll
then
supply
what
to
uses
that.
me?
I'll
Acha,
supply to that.
show me this letter dated 17/11/21 by which vacancy was not there, he was communicated.
17/11/21.
Mm.
11, page 35.
35.
Mal.
अच्छा अच्छा ये जो है ना वो जो बोला है कि he had approached this court by filing, उसके पहले एक sentence लिख लो ना. उसके पहले the petitioner was ultimately apprised of by the director no, you see, finally the petitioner came to know from the letter issued by the Director of Agriculture BTC Kokrajhar to the Honorable Chief Executive Member, Bodoland Territorial Council, Kokrajhar, that there were 29 cases for appointment on compassionate basis and the petitioner was one of them. But no one could be appointed due to non-availability of vacancies. And as such, it was stated therein that petitioner's case could not be considered. उसके बाद नीचे चले जाओ. Full stop. By the said order, वो बाद में हाँ. By the said order, this court the respondent authorities were directed, more particularly, the district level selection committee was directed to consider the case of the petitioner in terms of the OM number ABP dot 50 slash 2006 slash PT dot P is T small letter, dot slash 182 dated 1/6/2015 and to pass appropriate orders within a stipulated time. Within a stipulated time? Within a stipulated time. Full stop. Para. Pursuant to the same, the district level selection committee, which was constituted by the BTC, held its meeting on 28th of September 2023 and took up all the relevant cases. Full stop. In case of the petitioner, it was stated by the DLC that the petitioner has applied for his compassionate appointment after the death of his father on 21/1/2002. No, that will be the date of which? After the death of his father, date of his father, and that the DLC meeting was held first in the year 2016, and that 2016, and the case of the petitioner could not be considered due to lack of vacancy. Full stop. It was further observed by the DLC that the vacancies were available when the meeting was held, and that and the name of the petitioner was recommended for his appointment on compassionate ground against sanctioned vacant post of grade 3 under the Agriculture Department BGC, and his case was directed to be placed before the SLC of Government of Assam through Welfare of Boroland Department. Full stop. Para. In pursuance thereof, the said no. The Secretary BTC Kokrajhar, by a letter to the Commissioner and Secretary to the Government of Assam, had requested for placing the case of the petitioner before the SLC meeting. And thereafter, the Secretary of Bodoland Territorial Council's, oh, same date? No. Thereafter, by the same authority, thereafter, the same authority, huh? Not by. Thereafter, the same authority, by letter dated 28th of February 2024, addressed to the Deputy Secretary to the Government of Assam, recommended the case of the, recommended, nahi, I have to submit here with the required documents. Achha, I have to, কি কলো, by letter dated, no, but on 20th of February 2024, had submitted the required documents in respect of the petitioner and others, and as well as the vacancy position to be placed before the SLC. In the said letter, the name of the petitioner appears at serial number 5. Appeared at serial number 5. Thereafter, all the required documents were placed before the authority concerned. The vacancy position was also placed, and it is the case of the petitioner that there was a vacant post. There was one or others, one or more. There were vacant posts in both the grade 3 and 4. Para. Subsequently, the meeting of the SLC was held on 31/8/2024, and the case of the petitioner was taken up. And in its decision, the SLC stated that more than 23 years have elapsed from the date of death of the petitioner's father, and that during these years, the petitioner and his family had survived, and they must have got other means of subsistence. And on the ground that delay is a important consideration for giving compassionate appointment, the petitioner's case was rejected. Full stop. It was further stipulated in the said decisions of the SLC that DLC had not recorded any ground for recommendation, and in particular has not made up a case to justify requirement of compassionate appointment after over 23 years of death of the government employee. It is this decision of the SLC which is put to challenge in the instant petition. Mr. J.I. Bormia, Learned Counsel for the petitioner, submits that the petitioner has been trying his best to get an appointment on compassionate ground right from the death of his father by making an application within a period of 1 year from the date of the death of the petitioner. But due to one ground or the other, his case was not considered. First, due to lack of vacancies. Second, there was no district level selection committee was in place. And lastly, that many years have elapsed from the date of his father's death, of the petitioner's father's death. he submits, full stop, he submits that the only ground for rejecting the petitioner's claim is that many years have elapsed, which should not have been the consideration by the SLC, since he has been trying his best and years have elapsed, not due to his fault. He placed that DLC, after due consideration, has recommended the name of the petitioner to the vacant sanction post of grade 3, but SLC had rejected on a ground which should not have been the region. On the other hand, Ms. M. Bhattacharjee, Learned Counsel, you have placed some decisions, right? Or not required?
I have placed this.
He to substantiate
Also, my lord, compassionate appointment still exists, my lord.
to substantiate his argument, he has placed judgments as follows. Acha, which are the judgments?
Judgment, I'll give it to Martin.
Okay, you give it to him.
Because other than we also need to counter his judgments, what he is realized,
I'll give it to you.
what he realized.
Division bench
He's
judgment.
submitting irrelevant judgment.
Great judgments.
Because
Married-
lordship,
married
one
woman,
thing-
what is-
One thing that.
what
I
my
want to
learned is in
clarify,
submit.
lordship. Because admittedly, this petition has been filed in August 2025. And in September 2024, notification was issued, no more compassionate appointment, lordship. Thereafter, on 30th August, I think on July, an order was released.
That we know
yes.
that no longer, but then
Yes.
his case is an old case,
It is
2002.
the old case. Old cases have been asked, make an application. This was well advertised. There was not only publication in the website, there was a paper publication also. So he has not participated.
Acha, show me that notification by which it was banned.
Searching and getting from the internet and giving it.
No, that will be available to all. Where is that notification?
Yes,
That
because he-
notification is not
he
applicable
has
in my
suppressed
case.
Show me that
and
notification
misleading
once.
this Honorable Court, Lordship.
And
Show
so,
me
He has suppressed everything and misleading, Lordship.
so party BTC DLSC lordship. Every region, every ground stated lordship in our
It's okay,
mining.
you give me the notification when it was banned.
My
This will be available very
Yeah,
easily.
I did not get, my lord. Yesterday judgment, my lord, Supreme Court, my lord, that has been relied by virtue of the full bench, 6 bench decision, my.
And my lord,
I have given my, just now I have printed.
Acha, you give the judgments, huh?
I have given.
Ms. M. Bhattacharjee, Learned Additional Senior Government Advocate, had placed had submitted that the delay is a valid consideration to be considered. Valid reason, delay is a valid reason to be considered by the selection committees, since it is a subtle law that the compassionate appointment should not be granted after a long delay, since in the said case, the situation of the of the candidate becomes better with years. She submits that compassionate appointment is granted only for the region to avoid vagrancy, and that this family survives, and that should be immediate in nature after the death of the government employee. When the same cannot be granted, over the years, the candidates search for other ventures, and on obtaining the same, they survive. And as such, no ground for compassionate appointment exists after many years. She relies on the judgment of Devabrata Tiwari She relied on a judgment delivered by the Honorable Supreme Court in state of West Bengal versus Debabrata Tiwari, reported in 2025 5 SCC 712, wherein it was stated that delay of several years becomes a important factor while granting compassionate appointment. Because in the meantime, the family of the deceased get enough means to sustain themselves. She also relied on the judgment of this court what else? What are the High Court judgment you relied on, Ms. Bhattacharya?
One 2508/2020.
2508. One second. 2508. And the other?
That is the WPC 501/23.
Okay. She had also relied on the judgment delivered by this court in writ petition number 501/2023, as well as in writ petition number 2508 of 2020. Further, she has relied on the judgment delivered by this court in writ appeal number 93 of 2024.
There actually nothing has been referred to this, simply it has not been entertained. The spirit of Debabrata Tiwari has been
Yes,
observed by
followed.
the, yes, Honorable Division Bench Lordship. Because nothing irrelevant or against the law has been, could be projected by the council.
She also submits that the petitioner had not tried after giving his application in the year 2002 and after getting the consideration order in the year 2002 itself. 2002, right?
There is nothing.
No, the Justice Ranjan Gogoi's order was of 2002. Two.
And then on 2023 on.
Yes.
Long gap of 21 years.
2002. She also submits that thereafter, the petitioner filed an application in the year 2023. So for a long 21 years, 2002, 21 years, the petitioner sat silent, which shows that he had means to sustain himself and his family. And as such, has relied on the decision of the Supreme Court, which which held that long delay will be an important factor to be considered in compassionate appointment. Para. It is noticed in the impugned order, it is noticed in the decision of the SLC, where the case of the petitioner was rejected, that the SLC has rejected the case of the petitioner, not only on the grounds of delay, but have also therein stipulated that DLC has not recorded any ground for recommendation and has not made up a case to justify requirement of compassionate appointment after 23 years of the employee's death. On further seeing the DLC's recommendation, it is crystal clear that the DLC has stated that petitioner's father died in the year 2001 and the petitioner had made an application in the year 2002 for compassionate appointment, and that thereafter the DLC meeting was held in the year 2016, and due to lack of vacancy, the appointment could not be granted to the petitioner on compassionate ground. The DLC has also considered the order of this court, wherein it was stated that if sufficient vacancies are not there in any particular office, the petitioner may be accommodated in other departments for appointment on compassionate ground. अच्छा से लिखना है, I don't know. Thereafter, the DLC had recorded its finding that vacancies were available at that juncture and the case of the petitioner was recommended against a sanctioned vacant post of grade 3 under Agriculture Department BTC, and as such recommendation was made for his appointment and the case was directed to be placed before the SLC. However, in the DLC's decision, it is not stated as to the requirement of giving appointment to the petitioner against the said vacant post. It had not dealt with the numbers of years that has elapsed from the date of his making application. In the judgment of the Honorable Supreme Court in Debabrata Tiwari, Supra, it was held that compassionate appointment is not a vested right, and the same is related to financial conditions and hardship faced by the dependents of the deceased government employee. It was also held that compassionate appointment may not be entertained after lapse of a considerable period of time. It was observed that any delay in deciding such claim dilutes the sense of immediacy, immediacy of the requirement of maintaining a family. And with time, the financial circumstances of the family of the deceased changes. Full stop. However, it is not a hard and fast rule that in all cases of prolonged delay, the compassionate appointment should be rejected. what requires to be seen is the financial status of the family concerned. Since in the instant case there is a delay of, even if it is considered as a delay of many years, many years, even if it is considered as a delay, the DLC has not endeavored to find out by any means the financial status of the family. Full stop. As such, that was a factor which was considered by the SLC, that is, no reason given by the DLC. It can be a case, no interruption between order, huh? No interruption between the order. No interruption between the orders. It is seen. क्या बोला था पहले? As such, stop. This will not happen in each and every case. That the DLC has to find out the financial status of all the applicants. The instant case is a peculiar case where at first the DLC was not constituted. And when it was constituted, they found out that there were no vacancies. And thereafter, by virtue of this court's order, the DLC again started the process and found out that vacancies were available, and the petitioner was recommended for appointment to the sanctioned post of grade 3 under the Agriculture Department. Full stop. Further, it is reflected in this court's order dated 9/8/2023, wherein it was stated that after the erstwhile court's order of 2002, wherein it was directed that petitioner along with similarly situated persons should be considered for their appointment on compassionate ground, the matter was processed and considered at different levels by different offices over several years. And ultimately, by a communication in the year 2021, it was informed that petitioner could not be considered for appointment due to lack of vacancies. So it cannot be said that there was an intentional delay on either party. Intentional delay by either party, the petitioner or the department. Full stop. It cannot also be lost sight of the fact that although many years have elapsed, yet the petitioner and his family are not facing financial constraints. Full stop. Survival is a different thing, which every human being on this earth will have. But surviving with dignity is a different thing. As such, this court finds it fit to direct the DLC. So how will the DLC be formed now? There is no such thing now.
It is there, man. If your direction is there, they will form.
As such, it is direct. This court finds it fit to direct the. Show me that page where DLC was constituted by the BTC authority.
Case number 42.
33.
42.
No, no, it will not.
33.
More polling.
It is we direct the Deputy Secretary, Boroland Territorial Council, Kokrajhar, to constitute a DLC for the instant purpose, who will make an attempt to see the financial constraints, the financial status of the petitioner and his family, and make a fresh recommendation, keeping in view the vacancy position as well as the eligibility of the petitioner. Which will subsequently be placed before the authorities of, which will be subsequently placed before the departments, before the concerned departments of the district / territorial council for due consideration. And after the consideration, if any, the council will send the proposal to the state level committee for approval. This is as per the OM dated 1st of June 2015. Accordingly, the decision of the SLC with regard to the petitioner, namely Shri Bijoy Deka, is set aside. Petition is disposed of.
Lordship,
One
if I
thing, my
may
lord.
just appraise your lordship. Lordship, presently, I just get the notification and lordship. Presently, there is no DLC and SLC.
No,
lordship.
presently
It
there
has
is no.
already been taken away, and I have placed the lordship, the notification, and also the order calling for the applications.
That
So
will not affect
this,
my case, my lord.
this is
One thing, my lord.
humble submission. If my may lordship, my humble submission before your lordship is that this has actually attained its finality. So even if he had the agreement, this was filed much after passing of the notification of 2024. He could have challenged. There are many who have challenged, who came before this honorable court, and they availed the opportunity to apply before the authority if they had any grievance against the
This
SLC
is
or
notice of.
yes, lordship. And
So,
this
in
has been
compliance
well
with the-
circulated, lordship. This has been
One
well
second, I'll just go
circulated,
through.
lordship.
Hearing appointment.
This has been well circulated. There are number of cases, who have taken
What is this memo?
liberty, who
Memo ABP 104 dated 18/9/2024.
Yes, 89 also I have placed. This is a
89.
notification
Huh.
where the compassionate appointment has been withdrawn. Because in 2017, lordship, it was started compassionate family pension.
No, what
lordship.
will, this is prospective effect, right?
Prospect.
Yes, from that.
Prospective.
No, in 2017, it was there. 2017, there was a notification. From 1st April 2017, there was no compassionate appointment, lordship. It was compassionate family pension. Subsequently, also, these were dealt because there are many pending cases, lordship. This was dealt by, there was orders passed by this honorable court also. These remain pending in the SLC or in the DLC. So it was taken up. And finally, in 2024, this notification was issued, Lordship. Thereafter, a good number of petitioners, they were before this court challenging this notification.
Notification,
Yes,
yes.
and
That was the-
accordingly, yes.
That was a,
And accordingly, this honorable court has passed an order on 3/4/2025. So the cases which were pending till 3/4 or filed before 3/4/2025, this has to be dealt in putting with the order passed by this honorable court. So there was a direction to take up all the matters and have to look into each and every case, Lordship. And accordingly, DLC and SLCs has been formed, Lordship, and this has been, yes, all the cases has been dealt. So presently, Lordship, there is no such, because this has been
No,
taken
that
up.
is why I've said that they will
Yes,
constitute a
and
DLC.
that's why, Lordship,
Supreme Court
this
has given yesterday.
Lordship,
given
Supreme Court is separate thing, Lordship. It is not in respect context with the case of the Assam, Lordship.
Compassionate appointment, my lord.
It may be
What I have
compassionate
said is
appointment
this.
with other cases.
This is what I have said is this is a peculiar case.
And
This is not like
no,
general
Lordship.
cases.
And thereafter, Lordship, on the basis of this, applications were called. So if he had the agreement, he could have, because there were many, even if this case was pending, there were other cases also who sought liberty. Yes, we want to file. Yes, Honorable Court has given them liberty to file, and also with a direction to look into their case, Lordship, consider their case. So this is not here. Now they are on the different footing, Lordship. And think this, everything will be reopened when the bodies are not in existence, Lordship.
No, bodies are not in existence. So I have said the secretary will form a DLC and then give the proper report.
Lordship,
Only peculiar facts of this
Because
case.
It is the decision of 23, my
No,
lord.
it is in the peculiar facts of this
Yes,
case.
my lord.
And
time will
Lordship,
be given, my lord.
admittedly in the judgment
And the exercise
order
be
of this
undertaken
honorable court
preferably.
also is there from 2002, 23 is the case. Lordship may, if your Lordship may kindly.
It's
peruse
okay. I have
this one.
dictated. I will consider this notice and I'll, if required, I'll
Yes,
make some
Lordship.
changes.
Lordship kindly go.
Okay. And further, it is directed that the authorities will do the exercise within a period of 2 months from the date of receipt of the certified copy.
Obliged.
Mm.
My lord, I have
It
given
would-
three
disposed of.
judgment, my lord.
Yes.
Even if I'll
Acha, you take these, your something is all.
Division bench, my lord, he knows.
Division, Lordship, this Abdul Kader Bakshi is not applicable to him.
It's okay. I will not say what is
Because Lordship, he has not challenged this notification.
আচ্ছা এখানে দি দিয়া এখানে মই ইয়াত ৰাখিছো এই দুটা ইয়াত থৈ দিম এইখিনি দি yes yes Mr. Kumar.
Here I have earlier filed an affidavit from the GMC. Subsequently on 9/5, I have filed an affidavit from the its parent department, Department Housing and Urban Affairs. The affidavit is not on record, my lord.
I knew this would come on, that's why I got one on photo stat. This one,
Also.
6-page affidavit, they have annex 1, annex.
Housing department is required, he said on the last
Yes,
of.
last again. The affidavit has been filed, my lord, stating that
Housing department is filed.
Filed.
Oh, filed. Then
My
friend
friend ought to
purpose.
have mentioned it in the morning to tag it. I have brought a photostat copy
Where
to
it-
avoid this situation.
where is, my lord?
acha, but this is my housing.
With my case, then you will have your time. Well, this is one of those cases.
No, in between your argument, they will come up with something. No, I have to file affidavit. That's why I'm asking.
why
them
my
for-
lord-
Yeah, that's why I brought an extra copy.
No,
They
that-
can go
What
ahead.
else you require?
No, that's why, my lord, that where here the Department of Housing, the Department of Housing and Urban Affairs is the parent department of the GMC. GMC had written a letter demanding money, that amount for the pension of these petitioners, my lord. So that is, the Department of Housing being a parent department has forwarded to the Finance Department. In the last page of the affidavit, I have seen that is the online application to the Finance Department. Now, Finance Department have to approve and release that particular amount. The moment that that pension amount, whatever is due and whatever the area amount, that will be released, my lord. Only thing is that now the Finance Department to find it out, my lord, whether this has gone to them and whether they are going to pay it or this person.
Yes, Buddha Boko is the right person to say.
No, my lord, here I have got the affidavit filed by them, my lord. I would like to have the status from the finance department. I cannot say, my lord, outrightly now, without any instruction. It has been filed today.
No, it didn't file earlier, maybe he.
But it has been stated there on
So, Mr.
7.5.
Kumar, so
On
if
27
that
it
is
was-
allowed, then the repetition stands allowed, right? If you give concurrence for payment.
Yes, let me have the instruction on that point, madam. If that concurrence is given, the entire plea for pension will be released.
Well,
It
this
was
is
filed on online on 7/5/2026.
So Kumar can get relief from this side or that side also.
Yes,
So
we'll get the
if if Kumar is agreeable to get relief from that side, then we can defer the matter.
No, your lordship will.
No,
defer
I
it,
pay for 7 days time.
Malad-
I'm not paying.
Malad, not 7 days, not 1 day. This is a second round of litigation. Your lordship will see how much respect they have shown to the orders of this court. Your lordship will kindly look at page 75, the first order passed by the
I
court.
know the anxiety, my lord, that the pensioners, my lord. Only thing is that.
No, it will be people with salary are difficult to survive. Here you are denying these persons this pension from January. They have not pension. These are all senior people, citizens who have given the best of service to the GMC. On one pretext or other, you will deny it. We came before the lordship. Kindly look at the first order of this honorable court. It starts from page annexure 3, page 75.
They are very late in giving reliefs. In the earlier case, you have seen 2002
Yes,
he made
yes.
application
No, this is
immediately.
this is more worse than this.
Round or the other, he was
Yes.
not given, and now
Yes,
they
and-
say after
My lord,
3
we
years,
came
our hands are
Situation in the
tied.
GMC is different, Malati. There was no pension. The pension regulation was
Oh,
14.
You
Then
are
it
not
was
giving
being
it from your
pension was
pocket.
The pension was
Sir,
given.
please let me
Thereafter,
submit
my
my
lord,
case. After that, you will
thereafter there is
submit.
some irregularity.
Ah.
That's why the
No,
application was
this
made
is-
to the parent department to finance department. Money comes 12 crores, 13 lakhs, it will be released. Man. I'm waiting for that particular amount of money from
My
the
lord,
department.
your lordship will kindly.
But how long will the petitioners wait?
My lord, let the finance department have the instruction, my lord, whether there is leasing.
My lord, how they violate the undertaking given to this court. Your lordship will kindly look at page 77.
Hmm.
Your lordship will see.
Hmm.
The claim, this was filed in 2017.
Hmm.
The claim made in this petition is for grant of areas of the pensioner benefits in terms of the provision of the Gauhati Municipal Corporation Employees Provision Regulation 2015. As far as the entitlement of pension is concerned, the same is not in dispute. The only issue is about the non-payment of the areas of the pension to the petitioners. It has been submitted that the GMC authorities have already undertaken the process. Learned Standing Council, GMC, submits that the authorities will look into the matter after making necessary verification and make payment. In that view of the matter, let the respondent number 1 take appropriate step for release of the same after making necessary verification as expeditiously as possible, preferably within a period of 6 months from today. This was on 13/3/2029. They don't do anything within 6 months. Then we came in contempt. That is at page 78. The operative portion, your lordship will find at page 81.
Contempt close.
My lord, why we had to file a contempt 2019, 6 months. Then they released it on 2022. Even after 6 months period has over. It is submitted by Learned Council for the petitioners that the order dated 13/3/2019 passing has been complied with. This contempt petition is closed.
So
Then, my lord,
areas paid.
area paid. Now, what they have done from this month, I have given your lordship will see at page 83. My lord, these are people who have to pay for their medical bills and also many of them, 2,000 employees, my lord. Your lordship will see. Every month they will delay it. Date of payment, 26, page 83, 26/4/2024, 18/6, one they have given. On most of the occasion, your lordship will find that they will not pay
So
the
for
pension.
March 24, they paid it in April 26.
Yes. Date of payment. Now your lordship will see from
March?
this, from
Should have been 1st of April or
Yes,
2nd
sir.
of April.
First week I
Within
cannot.
7 days.
Yes, the first week they should have normally paid. And now the predicament of all these persons is that from January, today we are in
June.
They have not paid their pension. What is this, my lord?
A regular pension.
Regular pension, my lord. How these people will survive, my lord?
Why did they stop?
No reason. They said that it is fun. It is no money. The government, my lord, I'll not say anything, comment on the financial capabilities of the government. These people, they should not run from desk to desk to give their
Very
pension.
bad, very bad.
This is-
No, I mean, they are the same people working in the
Yes,
GMC.
yes, retired, all retired. Some have, and during the pendency of this petition, I think many of them have expired.
Now
Because
who are the petitioners? The association?
the association consisting of nearly about 2,000 employees. All these old people, they without getting their pension, they have expired only in the meantime.
So why were the pensions stopped from January?
They said no money.
Lack of fund, my lord. That's why there is.
Lack of funds.
Lack of fund. That's why the.
We all know, we read in the newspaper where
No, no, my
funds
lord,
go.
that's
I
why
don't
that
want to
application was
comment
made
on
to the government, to the his parent department, and parent department forwarded to the finance department. 12 crore, 13 lakhs. That proposal is there.
For all those people.
Yes,
For
only
these 6
specifically for
months.
this, specifically for this
But
pension.
why? Why so late? Why did you stop? Pension.
Funds were not there, my lord. That's why, my lord. If the funds come, then let the finance department have the instruction, my lord. The moment is
Before the
constantly-
election, government
Lack
has
of
all the
for
funds to
payment
give
of
the
pension
freebies.
is too much to say.
My lord,
The
I will
lords
not
will give a
comment on.
chance, my lord, to the finance department to find it out, my lord.
No, I'll give an order, finance department to immediate release.
Yes,
And
that's
that-
what I'm praying, my lord.
The
That's
fund-
our
If
prayer.
that can be done, my lord.
Where they get the funds, they only know. Why is stopping pension?
No, it's not, my lord, it's the pleasure to.
Of old
stop pension.
people, they cannot even work
No,
outside.
no, it is not a pleasure, my lord. That's the difficulty, my lord. That's why, my lord, I have shown the affidavit of the parent department that funds are not there, so the.
Considering the urgency, can it be on Monday? There is an affidavit that it has been submitted on 15/6. Let me have the instruction about the status, then lordship can pass an order. What is the status, whether we have received or not, my lord, at least.
But the thing is wrong. I mean, we have
3
stopped
days, they have
from.
waited for another.
No, your lordship will direct them
No, they
specifically
will
within a
wait
time
for
frame.
even one
period.
day.
Lordship.
They will not wait for even. These are pensioners. These are
No,
old
even
people.
then, on Monday, nothing will happen, my lord. Lordship.
Why not? 3 people have died during the pendency of the last order. Now another
is
person's made.
pathetic.
This
This
is
should not
this
be
is not
done.
the way
So
to
it's
deal
not
with.
about one.
What I've heard is correct.
No, I understand, my lord. Nobody is denying that, otherwise the proposal would not have been moved, my lord. Nobody is denying their right, my lord. Let it be on Monday, my lord. At least let me have the instruction, my lord.
From January till
Regarding the
June,
statement,
no
madam.
money.
Okay, Monday I'll dispose it
Yes,
of
ma'am.
Mr. Kumar.
Yes, ma'am.
Okay. Heard Mr. B.D. Kumar, learned senior counsel, assisted by Mrs. J. Kumar, learned counsels for the petitioner, and Mr. S. Bora, learned standing counsel for GMC.
GDD, Department Housing and Urban Affairs, and GMC. Response number 1, 2, 5, and 6.
Paisa. Department of Housing and
Urban Affairs. ma'am.
Urban Affairs, as well as GMC, huh? And Mr. B. Gogoi, the learned standing counsel for the finance. This is a case where the petitioners, being retired employees working under the GMC, were denied their pension from January 2026 till date. And the ground taken by the respondents is the lack of funds. The facts reveal that it is a very pathetic situation that the retired people don't get their pension, that too midway. And the reason being lack of funds. Mr. B. Gogoi, however, submits that by Monday, he will bring the instructions as to why their funds were not released. Prayer is allowed.
Your lordship will also direct them on by which particular date they will make the payment, because these persons are waiting for their payments from January. So otherwise they will say Monday we are releasing it. They will again indefinitely they will delay it. So they should also come up with the instruction within what period they are going to release this money.
Mr. Gogoi will also place the instruction as to on which date the department would release the pension amount.
Well, the sanction, lordship is a sanction. We will not release it, it will sanction. By which time, by what time it will be sanctioned? They are sought for approval.
They want to sanction
They
it,
are the one.
After approval, what happens?
Finance Department sanction it.
Concerned department will release it there.
Then the fund will come to the
Not that
through parent
finance will
department,
release.
parent department to the GMC. The GMC will get the fund, then we'll release it.
Then no need, Mr. Kumar. Once the approval is given,
Yes.
we will fix a date, you
Yes.
pay it. Last one and to Narayade. Prayer is allowed. List this matter on 8th of June,
8 of
2026. This you can take it back.
Yeah.
Yes, Mr. Bothakur.
Pleadings
Yes,
are
Mr.
complete.
Bothakur. Both Bothakurs. Yes.
Pleadings are, my lord, complete
So it can be taken up
For disposal.
for
for disposal. You're ready?
Yes,
Yes, yes.
fine.
Ready?
Yes.
Yes.
This, your lordship, the petitioner is aggrieved by the proceeding as well as the order, your lordship, by which he is dismissed from service.
Oh, morning it was called and then I told your junior to find him out, right? Oh, okay. So you are challenged a disciplinary proceeding.
Lordship, that page 64 is the order by which.
64.
Page 64 by which the
Hmm.
punishment of dismissal from service was inflicted on me.
Just go through the order bit.
Lordship.
Where an initial inquiry report was submitted by the Deputy Commissioner regarding the supply government fund. Okay. And whereas based on the report, a diploma initiated against Sushanta Kumar Sharma. So you are Sushanta Kumar Sharma?
Sharma, yeah.
And whereas as per report of inquiry submitted on 13/3, it was found that it was municipal government fund for implementation during the period. And whereas Sushanta was served with an official inspect the inquiry report, so have made a written statement of defense against the inquiry report, whereas after facts and charges. Sorry, include the punishment of so and so. Service which allow no disqualification from future employment also.
Since dismissal.
Dismissal, yes.
Act as a disqualification.
Where is the Assam Public Service has agreed to the proposed penalty of dismissal from service which shall ordinarily be a disqualification. Now in light of every factual circumstances, I have been exercise the clause conferred on the 11. Appeal file. What about appellate authority?
Lordship, appeal has not been filed, your lordship, in this present case, because your lordship, it is purely in violation of the principles of natural justice, your lordship, therefore.
But in the light of the so and so, 311, the governor of Assam is pleased to impose the penalty of dismissal from service.
Lord.
So without the appeal, can then this
Lordship, because your lordship, when there is a violation of the principles of natural justice, without even appeal, your lordship, to that effect, your lordship, judgment is also there.
No, this approval is given by the governor.
Governor has.
So appeal must have been preferred or what? No.
No, appeal has not been preferred. Appeal will have to be preferred to the, your lordship, before the governor itself.
So governor has given.
Already given approval, your lordship.
So appeal must have been filed and it was dismissed?
No, it is the order, your lordship, on the basis of enquiry report. This is by the disciplinary authority.
Okay.
This is not an appellate order. This is an order by the disciplinary authority terminating, dismissing my service.
But this is an order by the governor of Assam.
Yes, your lordship, that is there, your lordship. But ultimately, your lordship, in the name of governor, your lordship.
Yes, sir. In the name of governor, but okay, then
Then
what
now your
procedures not followed?
case essentially is this, your lordship, that your lordship, an allegation of misappropriation was brought against me. Your lordship will find that at page 20.
For implementation of some project, implement
Project, your
SBMG.
lordship.
You can say Mr. Bhattakur, other junior Bhattakur. Okay.
It starts with the genesis is this FIR at page 22, your lordship.
Yes.
With due respect, I, Sri so-and-so, Executive Engineer, Tinsukia Division, am going to state the following few lines for favor of kind necessary action. That, sir, one of our junior engineer, IC Hafjan section, namely Sasanta Sharma, has committed gross anomalies in payment of bills against the SHG NGOs who have constructed individual household latrines under SBM. He has not paid the bills against those SHGs NGOs that were earmarked from the division, rather as he is paid to other accounts like some hardware stores, Sevali, Sharma, Gugu, etc. Thus committed gross anomalies. Moreover, he became untraced without prior intimations to the undersigned. This process was conducted by him for last 2-3 years, so I request you kindly to make necessary arrangement for bring him to Tinsukia so that we can complete the process of reconciliation. And your lordship, on the basis of this, an FIR case has been registered under 409-420, in which I was granted bail, your lordship, anticipatory bail by this honorable court. Your lordship will find that at page 20, not relevant for our purpose, your lordship. I am just showing the. Then your lordship, page 31. is a report, Your Lordship, by the executive engineer, where he says that massive misappropriation of gov money under so-and-so was done by Sri Sushanta Sharma, PHA Hafjan, section to the tune of 4.60 crores. The money was allotted to construction of so-and-so. Division has earmarked the money for payment of bills by SHGs and just for construction of IHLs under SBMG and was transferred to GP accounts for final disbursement to self-help groups and NGOs, but instead of paying to the said junior engineer has transferred the following names. And this was reported, and your lordship will find, your lordship, there is an order at page 34 by which your lordship.
But instead of paying to the NGOs,
He has-
junior engineer has transferred to following names.
Lord-
Misappropriation is as such not there. He has given the money to somebody else.
But I am not on the merit, your lordship, I am
Acha.
on the procedural lapse. your
Okay.
lordship. That has taken place. Your lordship. Now your lordship will kindly come to page 36 is the so cause.
Yes.
May I read your lordship,
Hmm.
so cause? You are hereby asked to so cause under Rule 9 of Assam, the Service Discipline and Appeal Rules 1964, read with Article 311 of Constitution of India, why any of the penalties prescribed in Rule 7 of the aforesaid rule should not be inflicted on you on the following charge based on the statement of allegation attached herewith. That while you were serving as a junior engineer at Executive Engineer PhD Tinsukia Division, you did a massive misappropriation of gov money under SBM Tinsukia Division, due to which objective of Swachh Bharat mission has suffered, which violates Rule 3 of Assam Civil Service Contracts Rules 1965. You are therefore charged with corrupting the misappropriation of government. List of documents and witnesses proposed to be relied upon for proving the charge and allegations are enclosed. You should submit your written reply in defense within 10 days from the date of receipt of this communication, provided you do not intend to inspect the documents which have relevance with the issue under inquiry. In case you intend to inspect those documents, you should write to the undersigned for the same within 7 days from the date of receipt of the communication and submit your explanation thereafter within 10 days from the date of completion of the inspection. Your written statement stating whether you desire to be heard in person should be submitted undersigned within periods specified. Then your lordship, next last paragraph not necessary. Then my reply, your lordship may kindly.
No, the last paragraph not required.
Lordship not.
Decides to appoint an inquiry officer.
Inquiry officer will be appointed, your lordship.
If you so desire with the assistance of other government servants, okay.
That is
Then,
the normal procedure.
Hmm.
Now your lordship, page 37 is my reply. Now on merit, your lordship, I have submitted whatever is to be submitted, your lordship. Now your lordship will kindly see when the so cause notice from the so cause notice, the charge that has been brought against me is very vague in nature, your lordship. It has
a statement of allegations will follow.
no, that is not there, your lordship. That is what your lordship. Which means
No, they have said something, list
Yes.
of documents and
now your lordship.
witness proposed
That is why, your lordship, I will.
are enclosed.
So from the, my reply, your lordship,
Hmm.
may kindly come to my reply for last page, page 44.
Yes. This is a preliminary reply.
And reply to the aforesaid so cause notice. The undersigned could not submit effective and final reply because he was not provided with the opportunity to go through the inspect all the documents.
But he was given an opportunity.
No, your lordship, they have asked, your lordship. That is why I have given this reply and said that I will give a final reply and provide me an opportunity, your lordship. Your lordship will kindly see. The undersigned could not submit effective and final reply because he was not provided with the opportunity to go through the inspect all the documents, materials and statements on the basis of which the statements of allegation is prepared by your good office. The undersigned will file a final reply of the aforesaid no cause notice as and when he receives all the documents, materials and statements on the basis of which statement of allegation is prepared by your good office. And if the aforesaid documents, materials and statements are not served to the undersigned, and if the undersigned is not allowed to submit his final reply to the so cause notice that so and so by your good office, then it will be amount to violation of principles of natural justice. Specific plea, your lordship, that first give me those documents, provide me the copies documents, and then I will submit a final reply. To this, your lordship, they have not replied, your lordship. Had they given me the opportunity, it is duty is cast upon the authorities to point out to me that I have already given to you, but or you come by so and so date and inspect the documents. That has not been done. That is your lordship will kindly note.
But then you see in the show cause notice, you said that if you intend to inspect documents
That is
which
why,
have
your lordship, I
relevancy.
intended, that is why I wrote that letter, your lordship.
Acha. So you should write to the undersigned for the same within 7
Lordship.
days and submit your application.
Lordship.
No, actually, this will not be a reply. You simply write that I want to see those documents. Then after 10 days, you file reply. This was not actually, you should not have made the reply on 1/8/2019.
That's I
Then-
should have, your lordship, but whatever it is, your lordship.
Then,
Now, your lordship, after that, your lordship, they went ahead with the inquiry, your lordship. Your lordship may kindly come to page 55.
55, yes.
Thereafter,
Report of the inquiry officer.
Thereafter, what happened in the inquiry, I don't know. I have not participated in the inquiry. There is a one letter, your lordship.
Neither you are called to inspect the
I
documents.
was called initially, and on the first date, I say that it is not possible for me to come down from Dimahasa and to participate since I am not well. That is the first notice. They have recorded that in the inquiry report, and they have referred to a second notice, your lordship. And my specific case is that the second notice I have never received. And in my my statements on the inquiry report, your lordship, I have made this specific statement there in your lordship. Now, your lordship will.
But the second notice was issued, you did not get.
I said I did not receive it, and that is the pleaded case, your lordship. I will show that to you. Now, page 55, your lordship will find. Page 55. With reference to the subject cited above and in continuation to the departmental proceeding against you, I am directed to enclose herewith a copy of the inquiry report submitted by the inquiring officer, requesting you to submit a written representation on the finding of the inquiry authority to the department within 15 days from the date of issue of this letter, irrespective of whether or not report is favorable to you. Based on the representation submitted, this department shall proceed further with the inquiry. Now, your
Further with the inquiry. So inquiry has not come to an end.
lordship. Now, your lordship will kindly see your.
Further with the inquiry means disciplinary authority.
Department shall proceed with the, until inquiry will be completed at that point of time when disciplinary authority accepts the inquiry report and impose punishment ultimately. That is why this line.
Okay.
Now, your lordship will kindly see inquiry report, your lordship, at page 58.
Yes. This was given to you.
Lordship, this is given to you. In pursuance of Gov order number so and so, dated 18/5/2022, the undersigned has proceeded the inquiry against Sushant Sharma. In this regard, Sri Sushanta Sharma was asked to attend the office of the Executive Engineer PAC Tinsukia Division on 31/5/2022. Your lordship, by letter number so and so, dated 23/5/2022. By letter number 23/5/2022, I was asked to appear on 31/5/2022. But he informed by his letter number nil dated 25/3/5/2022 that he could not attend the inquiry due to communication bottleneck at Dimahasa district due to natural calamity. After restoration of communication to Dimahasa, he was asked to attend the inquiry by letter number so and so dated 2/6/2022. But he neither attended the inquiry nor he made any communication till today. And that letter, your lordship, in my humble submission, your lordship, that letter, your lordship, as I have pleaded in my reply, your lordship, that I have never received, your lordship.
6/22 letter.
6/2022. On receipt of report from the Executive Engineer PAC Tinsukia Division, by letter number so and so, the final report of inquiry is prepared as stated below. Your lordship will kindly note these words, your lordship. That on receipt of reports from the Executive Engineer Tinsukia Division, by letter number so and so, the final report of inquiry is prepared as stated below. That means, your lordship, the inquiry report is based on a report furnished by Executive Engineer PAC Division. Now, provision for construction of IHHL as per SBMG operational guideline number December 2024. This has been reference to the guidelines. Your lordship will find. Then page 59, your lordship will kindly come to the second paragraph. As per record, Sushant Sharma, JE, PhD, Tinsukia Division, Deed and Member Secretary of Bandarkhati, Bagjan, so-and-so, GP submitted fund demand in numbers against NGO SHGs to release of fund time to time without bills from NGO SHGs along with beneficiary list. Copy available documents enclosed as per Annex A. As per record, total number of 17 crore 98 lakh 79,900 only released by Member Secretary DWSC Tinsukia District to the BWSC as stated below. Now this is then as per record. Fund was released to the VWSC without bill submitted by NGO SHG along with beneficiary list. As such, it could not be ascertained the actual number of IHSL constructed at site and whether funds were properly utilized or not could not be ascertained, Your Lordship. First of all, Your Lordship, they have not been able to ascertain whether it has been properly used or not used, Your Lordship. Even if it
Acha, funds were released to VWSC is what?
it is village level, Your Lordship. One is district level, Your Lordship. DWSC, district. Then Your Lordship will kindly come to. It is also observed that no sanction release order number so and so while disbursed the fund number. No list of empaneled NGOs is available in the office of the Member Secretary, DWSC, come Executive Engineer, PhD, Tinsukia Division. Now, moreover, as per as guideline, funds should be released to the NGO or beneficiary, but no fund can be released to individual contractors other than beneficiary. But as per record available, it is observed that so-and-so Sushant Sharma, Deed and Member Secretary released the fund amounting to rupees so-and-so only to the individual as stated below. Then this, on scrutiny, fund demand submitted by so-and-so, it is observed that no name of Sevali Gogoi Sharma, Krishna Tulsi Hardware, and Das, Pupali Das, these are the names were found. Hence, Sushanta Sharma diverted the fund and violating the as guideline and made payment to the individual at his own risk as stated, which were originally disbursed for working of so-and-so. Now, then in view of the above, it is that there is a misappropriation of fund for implementation of so-and-so, Your Lordship. Now, here, Your Lordship, pausing for a moment, this report, Your Lordship.
As per record.
As per record. It is not, Your Lordship, as per the procedure to be followed by an inquiry officer, Your Lordship. Even if it is an expertise inquiry, even then they will have to adduce evidence. The presenting officer will have to present his case, will have to adduce evidence, exhibit the documents, Your Lordship, documentary evidence, Your Lordship. Based on that, there will have to be a finding to be given by the authorities, Your Lordship. That is absent in particular inquiry report, Your Lordship.
Presenting officer was appointed?
No, Your Lordship, we don't know. From the record of the proceeding, Your Lordship, inquiry report, that is not there, Your Lordship. That is why I have shown the first report, it's a first line itself. Then on receipt of the report from the executive engineer, that report is based on this inquiry report is based on the another report from the executive engineer, Your Lordship, and that executive engineer has not been examined as a witness, Your Lordship. Now, Your Lordship will kindly come to my reply at page 61, Your Lordship. That I have been served a copy of inquiry report, and after going through the contents of report, I found that the inquiry report, it is alleged to have served letter bearing number so-and-so dated 2/6/22, but in fact, no such letter was served on me. That further, it is alleged that the inquiry report that while I was posted at Tinsukia Division, I have released fund without bills from NGO SHGs along with beneficiary list, which is not correct. In fact, all bills are duly submitted and checks were issued by me after proper verification and after signing the concerned President GP. It is further submitted, the accounts are duly added. These are on merit, Your Lordship. And on merit, Your Lordship, I will not submit. That as per, and then para 5, Your Lordship will kindly see that as per inquiry reported, it is reflected the total amount of rupees 17 crores 98 lakh 73,978 only as released by Member Secretary of DWSC Tinsukia District to the VWSC and higher authority have released the said amount after proper verification and scrutinizing documentary bills, etc. Therefore, the allegations against me are not based on facts. That the allegation so and so, so and so, so and so. This is my reply, and then this was submitted, Your Lordship. This was this order.
Order.
Now, Your Lordship, my case, Your Lordship, is based on these lapses on the part of the departmental authorities in conducting the inquiry itself. First of all, Your Lordship, I have specifically asked for the documents that they have not provided to me. Secondly, Your Lordship, I did not participate, could not participate, Your Lordship, in the departmental inquiry, Your Lordship, that has been conducted by them, Your Lordship. And thirdly, Your Lordship, even as
You did not participate in inquiry means, you
because
did not
I
get
did
the
not
letter.
receive the second notice, Your Lordship.
622.
Lordship. Now, Your Lordship will kindly see that a third ground is this, even assuming that I avoided participating in the inquiry. The inquiry is not conducted in the manner prescribed by law, Your Lordship. It is the manner in which they have conducted the inquiry, Your Lordship. This is entirely foreign to the discipline and appeal rules, Your Lordship.
Okay, what is the procedure to be? It is
Lordship will
said.
kindly see the Rule 9 of the discipline and appeal rules, Your Lordship.
Yep, no. A2. Service manual টা হবে। Service manual এখানে পিছন এখানে education এর এই পিছন
And in fact, Your Lordship, if Your Lordship sees the so-called notice, Your Lordship, Your Lordship will find that Your Lordship, that they have made up their mind that I have committed the wrong, Your Lordship. Because Your Lordship, for a moment, Your Lordship, there is one judgment on this, Your Lordship, also. Today I don't have that, but I will show Your Lordship. So that you are hereby asked to so cause under Rule 9 of the Assam Service Disciplinary Appeal Rules read with so and so. Why any of the penalties prescribed in Rule 7 of the aforesaid rules should not be inflicted on you on the following charges based on statement of allegation.
This is the format.
That is why, Your Lordship, that is the format. But in fact, it's from perusal of the reading of this particular so-called notice, it looks like they have already made up their mind to punish me, and then they have proceeded with the inquiry, Your Lordship.
Anyways, what
Now,
is
Your Lordship, Rule 9, Your Lordship may kindly see. Procedure for imposition of penalties.
1 second. 9. Yes.
Without prejudice to the provisions of the Public Servants Enquiry Act 1850, no order imposing on a government servant any of the penalties specified in Rule 7 shall be passed except after an inquiry held as far as may be in the manner hereinafter provided. The disciplinary
As far as maybe.
Lordship. The disciplinary authority shall frame definite charges on the basis of the allegation on which the inquiry is proposed to be held. And such charges, together with the statement of allegation on which they are based, shall be communicated in writing to the government servant, and he shall be required to submit within such time as may be specified by the disciplinary authority a written statement of his defense, and also to the state whether he desires to be heard in person. At the time of delivering the charge, the disciplinary authority shall invariably furnish to the government servant a list of documents and witnesses by which each article of charges is proposed to be sustained. As in this, then 3, the government servant shall, for the purpose of preparing his defense, be permitted to inspect and take extracts from such official records as he may specify, provided that such permission may be refused if, for reasons to be recorded in writing, in the opinion of the disciplinary authority, such records are not relevant for the purpose, or it is against the public interest to allow him access thereto. Provided that when a government servant is permitted to inspect and take extracts from official records, due care shall be taken against tampering or removal or destruction of record. 4. On receipt of the written statement of defense, or if no such statement is received within time specified, the disciplinary authority may itself inquire into such charges as are not admitted, or if it considered it necessary so to do, appoint for the purpose of a board of inquiry by an inquiring officer. The disciplinary authority may nominate any person to present the case in support of the charges before the authority inquiring into the charges. The government servant may present his case with the assistance of any other government servant approved by the disciplinary authority, but may not engage a legal practitioner for the purpose unless the person nominated by the disciplinary authority as aforesaid is a legal practitioner or unless the disciplinary authority having regard to the circumstances of the case permits. The inquiring authority shall, in the course of inquiry, consider such documentary evidence, what your lordship will kindly note, such documentary evidence and take such oral evidence that as may be relevant or material in regard to the charges, the government servant shall be entitled to cross-examine the witnesses examined in support of the charges and to give evidence in person and to adduce documentary and oral evidence in his defense. The person presenting the case in support of the charge shall be entitled to cross-examine the government servant and the witnesses examined in his defense. If the inquiring authority declines to examine any witnesses or to admit any document in evidence on the ground that his evidence or such document is not relevant or material, it shall record its reasons in writing. Then, if in the opinion of the inquiring authority, the proceeding of the inquiry establishes any article of charge different from original article of charges, it may record its finding. This is not required, provided the findings on such article of charges shall not be recorded unless government servant has either admitted the facts on which such article of charge is based or has a reasonable opportunity of defending himself against such article of charge. At the conclusion of the inquiry, the inquiring authority shall prepare a report of the inquiry recording its finding on each of the charges together with reasons therefor. Then the record of the inquiry shall include the charges framed against the government servant and the statement of allegation furnished to him under sub-rule 2, his written statement of defense if any, the oral evidence taken in the course of inquiry, the documentary evidence considered in the course of inquiry, the orders, if any, made by the disciplinary authority and the inquiring authority in regard to the inquiry, and a report setting out the findings on each charge and the reasons therefore. The disciplinary authority shall, if it is not the inquiring authority, consider the record of the inquiry and records its finding on each charge. Then the major penalties, if the disciplinary authority having authority regard to the findings on the charges, then this is, your lordship will find on the government, it shall make an order imposing such penalty, it shall not be necessary to give the government service any opportunity to making representation, provided that in every case where it is necessary to consult the commission, the record of an inquiry shall be forwarded by the disciplinary authority to the commission. Here, your lordship, that has been, commission's opinion has been taken and advice, and such advice shall be taken into consideration before making any order imposing any such penalty on the government servant. Then, your lordship, notwithstanding anything contained in this rule, it shall not follow the procedure. This is not required. 12, your lordship. Then 13. Now, your lordship, this is the procedure. Now, most important is the 6, where, your lordship, it shall, the inquiring authority shall, in the course of the inquiry, consider such documentary evidence and take such oral evidence as may be relevant or material in regard to charges. So, your lordship, when an inquiry is to be conducted, your lordship.
But if there are no witnesses, if there are no, then?
Without witnesses, your lordship, there cannot be any inquiry, your lordship. It is like, it is not, the rules of your lordship evidence is not required rigorous.
Witness has to be
so
there.
far as criminal trial is concerned, but some sorts of procedural.
So some witnesses from either side will have to be there.
Definitely, now your lordship, he has relied on a report by the executive engineer. You will have to adduce, the executive engineer will have to adduce evidence.
Otherwise, how can that report be proved?
Because your lordship, ultimately, like your lordship, there is a judgment, it says that even the content
has to be proved,
your lordship, even in disciplinary.
By calling the person.
Lordship, calling the person. Now it is pure.
It is a secondary evidence otherwise.
Lordship. And secondly, your lordship will kindly see that this is what they have stated. And finally, your lordship, they have taken opinion of the APSC, your lordship.
Where is that opinion of commission you said? Where?
No, they are affidavit, your lordship.
Acha, yes. Whereas a public service commission on being consulted in the matter has
Consulted,
agreed
your
to the
lordship, your
proposed
lordship will
penalty.
kindly come to page 11.
It's in the impugned order also.
This is there, and they have annexed this, your lordship, in their affidavit in opposition, page 115. Now, as per the law laid down by our High Court and the Supreme Court, this, before punishing me, this report should also be furnished to me, Your Lordship. That has also not been done in the instant case, Your Lordship.
No, report was given to you. You had made a reply.
No, report was not, the enquiry report was given,
Huh.
but opinion of the APSC was not given, Your Lordship.
Opinion was not required to be given to you.
Yes, Your Lordship. That is held by our High Court.
Achha.
And here also, Your Lordship, that has been, Your Lordship will find at page 115.
Hmm. Yes.
And finally, Your Lordship may see one more aspect, Your Lordship. Page 111.
Ajay, once I am directed by the Honorable Commission to say that the Commission agrees to the government decision of imposing major penalty. Avtar Singh, Kailash, Shushanto, then what?
Avatar Singh was of the same. Now, Your Lordship may kindly come to page 111, Your Lordship.
Hmm. Yes. This is
Lordship.
the meeting held on 23rd June in the office chamber of
Lordship.
regarding departmental proceeding. This is in respect of so many, oh no.
I will show to my part, Your Lordship.
This is what? This is a meeting held.
Lordship, that is why. Now, Your Lordship, when enquiry report was submitted, it is for the disciplinary authority to take his apply his independent mind to that. Now, where is that independent mind, Your Lordship? This is, Your Lordship, his order is completely influenced by decision taken in this particular meeting. Your
So
Lordship,
inquiry report will be given to the disciplinary authority.
Lordship, disciplinary authority
And
will
authority
my
will-
reply,
Hmm.
and then he will apply his independent mind and then punish me, Your Lordship, if he find it. Now, Your Lordship will kindly see, at the onset of the meeting, the chairman welcome all the members. Sri Paragmani Bora, inquiring
This is
officer.
the disciplinary authority.
Disciplinary authority is present, Your Lordship. Number one, Soyoda Abbasi. And inquiry officer is also present, Your Lordship. Paragmani Bora, Your Lordship. Now, at the onset of the meeting, chairman welcome all the members. Sri Paragmani Bora, inquiring come superintending engineer PhD Dibrugarh Circle initiated the meeting with due permission from the chair by discussing about the departmental proceeding against Sushant Sharma, JE PhD, Office of the Executive Engineer PhD Haflong Division. Sri Bora IO placed all the facts and records before the chair and explained that Sri Sushanto Sharma did and member secretary so-and-so, 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 Tinsukia district submitted fund demand against the beneficiaries empaneled NGO so-and-so for release of the fund time without bills. Then Sri Parag Manipura stated that then these are his statements, what is there in the enquiry report. Based on these facts, next page, Your Lordship. Placed by Sri Parag Mani Bora, the chairman come additional chief secretary to the Government of Assam PhD after thorough discussion with the members directed that as per Rule 10 of Assam Service Discipline and Appeal Rules 1964, the government servant Sri Sushant Sharma JE may be imposed with a major penalty leading to dismissal from service.
Direct.
Now, it is by the, not by the Your Lordship disciplinary authority. It is by the someone else. He has directed, Your Lordship, and based on that, this order has been passed.
How can he direct?
Yes, Lordship. Where is the application of independent mind by the disciplinary authority?
Thereafter, the meeting continued with due.
Then, Your Lordship, rest, Your Lordship, is not in respect of me, Your Lordship.
Achha. Although after thorough discussion with so-and-so, directed as per so-and-so, okay. Now, this is not at your, not
Not,
with
it is
regard to
respect
you.
of your avatars in Your Lordship.
Others.
In his case also, this honorable court interfered, Your Lordship.
So directed that so-and-so may be imposed with major
Lordship.
penalty.
Lordship. Now, Your Lordship will kindly see that Your
It is
Lordship
also not there that I have approved, I have accepted.
Lordship. Now, Your Lordship will kindly see page 81, statement of allegation.
This was given to you.
They say, Your Lordship, but I am, for the moment, Your Lordship, I am saying that this statement of allegation has been given to me. Now, Your Lordship will kindly see list of documents, report from executive engineer, and
Same
then
report.
list of witness, DC, executive engineer, Tinsukia Division. These two will have to be examined, Your Lordship, as a witness.
But they were not.
They were not, apparently, from the record of from the inquiry report, Your Lordship. He has only relied on a report by the executive engineer, Your Lordship.
The document.
Document, Your Lordship.
So that is your case.
That is my case, and Your Lordship will kindly see that these procedural violation has, in fact, Your Lordship, caused prejudice to me, Your Lordship. I did not get, number one, I did not get the opportunity, Your Lordship. The copies were not served with me, and they have not annexed any documents by which they can say that I have been given that opportunity to inspect the documents. That has also not been given. I have specifically mentioned that the second notice I have not received, and that has not been dealt with by the inquiry by the disciplinary authority at no point of time. In fact, this inquiry officer also, while considering the materials, Your Lordship, ought to have taken note of my defense in the form of my preliminary reply, Your Lordship. That was before him. That will have to be before him. But that has not been discussed.
No, but then you also have not followed the procedure properly. Because in the show cause, you were said that list of documents, you were supposed to, if you want to inspect, you tell us. You did not say that you had given your reply. And in the reply, you said that I want to inspect.
And that's a preliminary reply.
And second notice, perhaps there is something which you did not receive.
Lords.
Till then, okay, there is something. But then the order says the inquiry report is violative of this rule
Now,
9.
Your Lordship will kindly.
In my first blush, I am saying, I am yet to hear him.
Lord.
But Mr. Bothakur, whether this non-compliance of the what happened? Your pen fell.
Lords.
Must be a costly one.
No.
Acha, and it is non-compliance of the procedure, whether that will be fatal.
Yes, Your Lordship, that the non-compliance, the procedural safeguard is the essence of the proceeding, Your Lordship. The moment it goes, everything goes, Your Lordship. Now, Your Lordship.
Now, whether there is some rider-shider by High Court, Supreme
I have
Court.
not seen, Your Lordship. If they can show something, Your Lordship will kindly go through this judgment, Your Lordship. Para 17, Your Lordship. I'm reading it, Your Lordship.
Yes, para 17.
Even in case of ex parte inquiry, Your Lordship, like me, Your Lordship will kindly see what Supreme Court has said. Thus, even in an ex parte inquiry, it is sine qua non to record the evidence of the witnesses for proving the charges, having tested the facts of the case at the hand on the touchstone of the rules of so and the law as expounded by this court in the cases of Rupsi, Negi and Nirma so. We are of the firm view that the inquiry proceeding conducted against the appellant pertaining to charges punishable with measurement were totally vitiated and non-est in the eyes of law since no oral evidence.
Okay. So, no oral evidence, no evidence of witnesses.
And before that, Your Lordship will kindly find another paragraph, Your Lordship. There is a reference to another judgment that Your Lordship will get it at page para 15. Same view was reiterated in the state of Uttar Pradesh versus Saroj Kumar Sinha, wherein this court held that even in an ex parte inquiry, it is the duty of the inquiry officer to examine the evidences presented by the department to find out whether the unrebutted evidence is sufficient to hold that the charges are proved. Ultimately, that will have to be done, Your Lordship. Procedure will have to be.
Even in his absence.
Yes, Your Lordship. In absence of that, Your Lordship. And another aspect, Your Lordship will kindly note, Your Lordship. The rule specifically says that the charges will have to be definite, Your Lordship. Now, if Your Lordships go through the charges in the present writ petition, Your Lordship, Your Lordship will find that these charges are not definite, Your Lordship. They will have to come up with something, Your Lordship, more than that.
Let's see the issue.
In there, Your Lordship, statement of allegation, page 81, Your Lordship, may kindly see.
While you were serving as junior engineer, you did a serious misappropriation of government money under your view, which are meant for implementation of so and so. due to which objective of man so and so has suffered.
Now, your
badly.
lordship, how much money? Number one, your lordship, tentatively. Number two, your lordship, in which manner that has been done, your lordship?
No details, rather.
Yes, your lordship, ultimately, that is why the wording of the rule, your lordship, the definite charges will have to be framed, your lordship.
And of course, in the show cause notice, it is said that you had placed the demand.
Lordship, that is what
You
they
had
have.
submitted the bills, or where I have seen, I don't remember, in the show cause notice perhaps. Now, but whether the bills were submitted by him,
That, your lordship, my reply, since your lordship, I have not entered into marriage, your lordship, but your lordship, my reply, your lordship can.
okay, now that you are not entering into the marriage.
Now your lordship will kindly see another another judgment on this.
Okay, let's hear what Junior Bhattakur has to say.
Lordship, before that, I
One more
request the
judgment?
Judgments, your lordship. Your lordship, that is 2013 6 SCC 515, your lordship.
515.
515.
Okay, I can take it out. I have my.
Extra copy is it me. Para 15 and 16, your lordship.
Paragraph 15, 16.
15, 16. In Surat Chandra Chakraborty versus so and so, this court held that it is not permissible to hold an inquiry on vague charges, as the same do not give a clear picture to the delinquent to make out an effective defense, as he will be unaware of the exact nature of the allegation against him and what kind of defense he should put up for the rebuttal thereof. The court observed as under the grounds on which it is proposed to take action have to be reduced in the form of a definite charge or charges which have to be communicated to the person charged, together with a statement of allegation on each charge based on any other circumstances which it is proposed to be taken into consideration in passing orders as to be stated. The rule embodies a principle which is one of specific content of a reasonable or adequate opportunity for defending oneself. If a person is not told clearly and definitely what the allegations are on which the charges are preferred against him are founded, he cannot possibly by projecting his own imagination discover all the facts and circumstances that may be in the contemplation of the authorities to be established against him. Where the charge sheet is accompanied by the statement of facts and allegations are not specific in the charge sheet, but are crystal clear from the statement of facts. In such situation, as both constitute the same document, it cannot be held that as the charges were not specific, definite, clear. The inquiry should be vitiated. Thus, nowhere should be delinquent be served a charge sheet without proving to him a clear, specific, and definite description of the charge against him. When statement of allegations are not served with the charge sheet, the inquiry stands vitiated as having been conducted in violation of the principle of natural justice. The evidence adduced should not be perfunctory, even if delinquent does not take the defense or make a protest that charges are vague, that does not save the inquiry from being vitiated, for the reason that there must be a fair play in action, particularly in respect of an order involving adverse or penal consequences. Then para 17, the purpose of holding an inquiry against any person is not only with a view to establish the charges leveled against him or to impose a penalty, but also to conduct it with the object of such inquiry recording the truth of the matter. And in that sense, the outcome of an inquiry may either result in establishing or vindicating his stand, and hence result in his exoneration. Therefore, fair action on the part of the authority concerned is a paramount necessity. Then another.
But then I did not understand this sentence, paragraph 16, where the charge sheet is accompanied by the statement of facts and allegations are not specific in the charge sheet, but are crystal clear from the statement of facts. In such a situation, as both constitute the same, it cannot be held that the charges were. So if the other things shows, if the fact shows that the picture is clear, if the facts makes the picture clear, then in that case, okay.
But here, your lordship, where from the I get to know that facts are clear for me, your lord. Because charge sheet is replica of what is there in the statement of allegation, not more than that, your lordship.
Hmm.
The same.
The facts are not clear.
Clear,
It is a small one paragraph.
Lordship.
Hmm.
And then your lordship may kindly see another judgment, your lordship. 2011-14 SS.
The ultimate requirement is that he should know the acquisition. Yes, Mr. Bhattakur.
Lordship.
He should at least know what he is
Yes,
being
your lord.
accused
What is
of.
against him, your lordship?
But
What we
then,
are
see, in the show cause, while you were serving, you did a massive, same things without any details, rather.
Here, your lordship will get an, your lordship,
Hmm.
para, this is your lordship, para 11 onwards, your lordship. A plain reading of the charges. Charges, your lordship, here, your lordship will kindly see how charges have been given, your lordship. Statement of imputations while working as so and so. Then a plain reading of the charges and the statement of imputations reproduced above would show that only vague allegations were made against the appellant that he had sanctioned loans to a large number of brick manufacturing units by committing irregularities, but did not disburse the entire loan amount to the borrowers, and while a portion of the loan amount was deposited in the account of the borrowers, the balance was misappropriated by him and others. Similar like me, your lordship. The
Better,
details
your
of-
case is better. Balance
Be-
was with him.
Yes, that is not there.
That is not there.
The details of the loan accounts or the names of the borrowers have not been mentioned in the charges. The amounts of loan which were sanctioned and the amounts which were actually disbursed to the borrowers and the amounts alleged to have been misappropriated by appellant have not been mentioned.
So
We
this-
also find that along with the charge sheet dated so and so, no statement of imputation giving the particulars of the loan accounts or the names of the borrowers, the amounts or loans sanctioned, disbursed and misappropriated were furnished to the appellant. Yet the disciplinary authority has called upon the appellant to submit his written defense submitted in reply to the charges. We fail to appreciate how appellant could have submitted his written statement and defense in respect of the charges and how a fair inquiry could have been held unless he was furnished with the particulars of the loan accounts or the names of the borrowers, the amounts of loan sanctioned, the amounts actually disbursed and amounts misappropriated were also furnished in the charge sheet. As has been held by so and so, the ground on which the that your lordship has already gone through.
Yes. So it's okay.
Lordship, and your lordship, last
Things has to be specific.
lordship, and your lordship may kindly see this judgment, 2007-10 SC,
Acha, this is paragraph 11, right?
11-12.
And there will be no time to dictate the judgment here. 15.
It is on your lordship, the first question your lordship has put.
Yes.
That without appeal whether. Lord.
Justice Sandeep Mehta judgment, which paragraph you said? 17, right?
Lordship.
Yes, okay. Yes.
Para 13, your lordship.
Paragraph
Para 12 and 13. Before parting with the case, we may also deal with the submission of learned counsel for the appellants that a remedy by way of an appeal being available to the respondent, the High Court ought not to have entertained in his petition filed under Article 226 to 27 of the Constitution. There is no gainsaying that in a given case, the High Court may not entertain a writ petition under Article 226 of the Constitution on the ground of availability of alternative remedy, but the said rule cannot be said to be universal application. The rule of exclusion of jurisdictions due to availability of an alternative remedy is a rule of discretion, not one of compulsion. In an appropriate case, in spite of availability of alternative remedy, the writ court may still exercise its
subtle position.
Lords, then your lordship, in the instant case, though it is true that penalty order impunity writ petition was applicable in terms of the aforementioned regulation, but having come to the conclusion their order was per se illegal, being violative of the principle of natural justice, it cannot be said that High Court fell into an error in entertaining the writ petition filed by the respondent. Your lordship.
Yes. Pre-contingency when the writ petition seeks
Lordship.
enforcement of fundamental failure of natural justice where the orders proceedings wholly without jurisdiction. Okay. This is all? This is all Mr. Bhattacharya.
Lordship, Lordship.
This is all. Enough for Junior Bhattacharya. Yes.
I would like to, my lord, respond tomorrow, my lord, because I need to go through it. Today was a motion day, my lord, lot of matters. So tomorrow, lordship may,
Tomorrow is first item.
as first item, my lord.
Okay. I will in fact dictate whatever he has stated. So otherwise I forget.
Yes.
Huh? Tomorrow as first item, Mr. Bhattacharya.
Lord.
You need not be there, your junior.
My part is over.
Huh. And if anything is required, we will call you. I will not.
Lord.
Okay. Heard in part. Heard Mr. S. Bhattacharya, learned senior counsel assisted by Mr. S.U. Ahmed, learned counsel for the petitioner, and Mr. I. Bhattacharya. I. Bhattacharya, standing counsel for
PHE, my lord.
PHE department. Hearing remain inconclusive. List again tomorrow. That is 4th of June. As a first item. First item. Kal hearing day hai na? At 2. At 2.
At 2.
At 2.
Lords.
Okay, at 2.
Deeply obliged.
এইটো মোৰ চেম্বাৰত দিবা ন এণ্ড এইকেইটা এইকেইটা হা ডিচিশ্যন কেইটা দিবা হা য়েছ মিষ্টাৰ চমুৱা চিং ইউ আফটাৰ লং
Yes, I'm here, Mr.
So you went for some Vaishno Devi? No.
No, for some other work.
Okay. So what is this matter about? 4:30.
What has happened is the petitioner, he retired as a vice chancellor of Tesco University.
Acha. Pleadings complete.
But not complete.
There's a small affidavit I can see.
But that is an additional affidavit filed by me. Madam.
Bring on record certain subsequent events. So Mr. Chamua, you will file affidavit or not
We are
required?
waiting for the instructions for long, but I'm giving a mail today also.
Well, the principal respondents are Tesco University.
Tesco
and
University.
it appears for UGC.
Tejpur University.
I'm for the UGC, my lord.
Mr.
Acha.
KL used to, SCKL senior counsel used to appear earlier, madam.
So today too I did not see him.
But now perhaps he, because of
Tesco
his-
University.
So Miss Devi, you are appearing. Mr. Akedi Chaudhary is for
Union, my lord.
Tezpur University now is there.
Tejpur University also. So Mr. Chaudhary will appear, but not today, or what?
He's out of station.
Out. Oh yes, yesterday also there was a prayer. Okay, Mr. Bharadwaj, right?
But if it obtained instructions and filed their affidavit.
But Tejpur University is a necessary party. And
Well, that is what I'm saying.
so let Mr. Chaudhary come. When is he returning?
India.
Oh, acha. Then we can take it up next week. Okay. On the prayers,
I'll provide.
for the copy. On the prayer made by the learned councils for all the parties, list this matter on 11th of June, next Thursday.
Let me record our presence.
Yes. Mr. P. Bharadwaj, learned counsel for petitioner, and Mr. A. Chomo, Dr. A. Chomo, learned counsel for UGC.
University Council.
UGC, and Miss L. Devi for Tejpur University.
Yes.
Oh, appearing on behalf of Mr. R.K.D. Chaudhary, huh?
1, 2, and 3. 1, 2, 3, and 4, 5. 1, 2, 3, 4, 5. She is appearing. 6, I'm appearing.
Okay, 1, 2, 3, 4, and 5, Lovely Devi, 6, Mr. Chomo.
Okay.
We'll take it up next Thursday. Time being asan gire. So time being, what happened?
Taken any other day, senior leg.
As prayed for by learned councils of all the parties, list this matter on
Monday, Lordship.
17th of June,
Lordship, short date, Lordship.
short date. List this matter on 9th of June, next week, Tuesday. 29 to leftover in. Make it a man pass it.
Lordship, my senior has just left the court due to some urgency. So can we
The learned
also
counsel
amend?
appearing for petitioner has prayed for an adjournment, which is not objected to by the learned counsel appearing for the respondent. As such, list this matter on Mr. Dhar or Mr.
A short day.
List this matter on 12th of June, next Friday.
Right.
Yes, 33 D Deca. Yes. Yes.
May I please, your lordship,
Yeah.
the engaged counsel is out of station, so kindly.
For?
She was here only. Oh, she have left for some personal difficulty. Kindly take the matter.
4:30, nobody wants to do matter also.
Let it be then on Friday, lordship.
On the prayer made by the learned counsel appearing for the respondent, list this matter on Friday, this Friday.
Lordship, this is the recruitment. After 16 June, lordship.
After 16 June.
Lordship, here this, the recruitment process is already over. Although there is an interim order, lordship, there is a vacancy kept for the petitioner. But that.
To keep a vacant post.
Yes, lordship, there is an interim.
So, okay, after 17th, we will hear. Wednesday, 17th of June.
Otherwise, the issue is very small, my lord.
Very small day at this
I
hour.
understand, my lord. I don't want to, my lord, in the wee
When
hours.
he says it is small, my lord, it is not.
I am also small, my lord. and-
That is
and
why
it is also-
congratulations for your elevation.
My-
For your, yes.
I'm highly obliged. My lord, only thing is that, my lord, if can be taken up, there is some urgency in the matter. If it can be taken up on Monday, my lord.
Monday?
Yes, my lord.
Okay.
Monday is,
The issue is very, like, he's awaiting for a grant of NOC for pursuing his PhD in Tejpur University, and the session will start from this month itself. If the NOC.
Why are you not giving the NOC?
No,
I say he is.
Yes,
he has to
NIT
give.
is denying me NOC. The impugn order which has been passed is absolutely non-speaking,
You
one
also
line.
did your doctor PhD.
And
So let them let others also do it.
My brother-
Give the NOC.
had it been so simple, my lord, I would have done it right now. My lord, the difficulty is that he did not apply it in time.
Acha.
After taking admission, he has applied.
That I can satisfy your lordship.
Because
After taking admission, one cannot apply or what?
no, he has to take prior permission because
To pursue.
to pursue.
Because he has to take
Because-
regular
yes,
classes.
Yes.
All those.
Because he is a person of the person he is the in charge of maintaining the whole building and all engineering works.
So his work.
He is
will
the
get
isolated.
affected.
His post is an isolated post. So he is the
Isolated post. There are seniors in my department itself. My lord. My
But
lord,
then
what
still
happens-
you have allotted some important work.
Fine, if that be so, there has to be, that has to be
6 months. He
reflected
has
in
to
the-
be 6 months. He has
And
to
that
out
too, it's
be.
part-time.
No.
It's a part-time PhD.
In
6
few
months.
universities I have seen part-time only.
Yes.
My lord, even if it is part time, the first 6 months coursework is compulsory.
6 months I'll be there.
So 6 months we
I
cannot
need
afford.
NOC for 6 months only, study leave, so that I can just complete my 6 months course and I'll come back to my institute and serve for rest of the period.
That is what the department has to deliberate it upon this request. What he did, he took the admission, citing some false reason, he took leave, then he appeared for examination, entrance examination, took admission, then applied. And it was come into surface that when his NOC was rejected, then he applied for a EOL for 1 year, citing the health ground of his father. See? He said that his father is a bedridden person in Gauhati. He needs to take care of his father. So he need 1 year UL. On the other hand, he is applying for the PhD to stay in Tezpur University. Can he do this?
Lord, with all due respect to my senior.
We'll see. We will
These
see.
things are there. These things are not
Factually-
some-
factually
Part-time
incorrect.
only, but let's see.
Factually incorrect. I'll place the correct facts, my lord.
Okay.
Monday, my lord.
Okay. As prayed for by Mr. H.K. Das, learned senior counsel, assisted by Miss
D.
D. Mohanto, learned counsel for the petitioner. Placed this matter on 8th of June. Mr. Dr. H. Homua is for the respondent.
Respondent, the Milot,
For what?
NID Milot 2 and
NID.
National Institute of Design.
Oh, National
there are-
Institute
there are
of Design.
Tezpur University is
2
also
and 3
party.
Milot. 2 and 3.
Respond number 2 and 3 and Miss L. Devi for respondent number
Four.
for Tezpur University.
Yes.
For Tezpur University are present. Huh?
Lord, may I make a prayer? Can it be at 2, if possible, my lord? If possible.
Okay, I'll take it up at 2. Tell you one of your junior to mention it. When the matter reaches, I'll take it up at 2.
Fine. Highly okay.
Yes, Mr. Singha, Rana Singha is not there.
May I please stop? Possibly, we require further 4 weeks time to file an affidavit.
Okay. Miss L. Devi, Learned Counsel for
I'm appearing here on behalf of,
Mr. R.K.D. Chaudhary.
no, Lordship, we have PS Law Court.
Acha.
CGC.
P.S. Locker.
PS Law.
For appearing on behalf of Mr. P.S. Locker, Learned Counsel for the respondent submits that some time is required to file the affidavit in opposition. Prayer is allowed. Leaves this matter on.
2 weeks. Can it be on after 2 weeks, Lordship?
After 2 weeks means last week will be a motion week, I believe. So it will go after vacation. Okay. Place the matter on 19th of June. June, because last week will be a motion week, I believe, and then taking it further after the vacation will be too long, I think. We will see. If it is not filed, we will give another date, but try to file it.
Yes.
Yes. Orders. Mechanism of orders.
The earlier order,
Hearing.
APSC was directed
Huh.
to bring the select list and other relevant record.
Hmm.
But from the affidavit filed by the government in the original writ petition, the copy of the select list and other recommendations is with the higher education department, Lordship.
Oh.
That modification is required.
Mr. Bhuya, you will bring it. Earlier it was direction was given to her
The
to bring.
APSC, because after completion of the selection, all the documents were sent to the higher education.
Acha. Okay. Mr. S.
To you.
Yes. U. Datta. U. Datta, Learned Counsel for the petitioner submits that although by this earlier order, the records were directed to be placed by the Learned Counsel appearing for
APSC.
APSC, APSC, the said documents by law is sent to the Directorate of Secondary Education,
Higher education.
Higher Education. As such, he makes a prayer that records may be placed by the council appearing for the higher education. Prayer is allowed. Mr. S. Bhuya, the learned Standing Council for Higher Education would place the records on the next date. List this matter when? After vacation.
After vacation, because
List
this
this
is a whole
matter
record.
on 16th of July.
Um,
I'm appearing for action number 6.
Yes.
I'm appearing for action number 6.
Your name, please?
My name may be recorded.
Yes, your name,
H.
please?
Rahman.
H. Rahman, Learned Counsel appearing for respond number 6.
obliged.
Contempt. Yes, contempt.
Lordship, this order is at page number 10, Lordship. Since 2019.
But then no representation from the other side?
Yes.
Yes, some.
Lordship,
Some.
proposal.
Okay, what does
Budget
this
session will be sent on
instruction
this-
show?
On this new budget session, Your Lordship.
Want some further time?
Yes, Your Lordship.
Why resubmitting the proposal for area salary? When was the order given?
Lordship, 10/4/2018, Lordship.
18?
Yes, Lordship.
2018,
Since
Mr. Ram.
Lordship, last year also passed this way, Lordship. Since 2019, Lordship, kindly see the order, Lordship. 10/4/2018.
No, 24 is the order.
No,
Show me the order.
page 8, Lordship, annexure in.
But here in the Instruction, it is written 10/4/24 order passed in writ petition 4124
No,
of
Lordship,
2017.
see, Lordship, page number 8, Lordship, Annex
8.
10/4/2018, Lordship.
10/4/2018 and they made it 24. Very good. 10/4/2018 4124. See, Mr. Terangbe,
Yes, Lordship.
is this the way to write? They are so casual. The education department, I don't know what will happen to them. What was the direction? To give him the area salary.
Yes, Lordship. Page 10 is the relevant part, Lordship.
So many orders have been given. You see, this contempt application is filed in 2019. We'll call for the personal appearance of. There's no way out. Personal appearance of whom?
Joint Secretary to the Government of Assam.
This petitioner was working as what?
Lordship, as a work, grade 4 employee in high school, Lordship. But yeah, so far, high secondary school.
He retired?
No, Lordship, he is working.
Still working?
Yes, Lordship.
Heard, Mr.
Is it Dr.
P.J. Doctor, Learned Counsel for the petitioner, and Miss H. Terangpi, Learned Standing Counsel for Elementary Secondary Education. This is a contempt application filed for alleged non-compliance of the order dated 10/4/2018. By which it was ordered that petitioner should be paid his due wages for the period of service rendered by him. And the entire exercise was directed to be completed within 3 months from the date of receipt of this order. However, it is seen that 8 years have gone by and the petition and the order of this High Court is not followed. Miss H. Terangpi, Learned Standing Counsel for Higher Education, Secondary Education, has placed an instruction issued by the Director, Secondary Education Assam, by which it was intimated that in compliance of the High Court's order, the Directorate of Secondary Education has furnished the checklist and documents pertaining to the arrear amount of the petitioner to the government for taking necessary action during the financial year of 2025 to 26. It is further stated the government, on the other hand, had instructed the Director of Secondary Education to resubmit the proposal for arrear salary and to send the checklist and other documents again. For onward submission to the Finance Department. It is noticed that in the said instruction, the order was stated to be of 10/4/2024. and it cannot be considered that the said date is is stated as inadvertence. Inadvertence, huh? Because even in paragraph 1 of the said instruction, the said date is written that High Court had given the order on 10/4/2024. Rather, the High Court's order was in the year 2018. This shows that either it was intentionally put or the authorities has acted in total casual manner, which is not expected from the Director of Secondary Education Assam. Further, the directions were given in the year 2018 and actions were purportedly taken during the financial year of 2025-26. This shows their total negligence of the High Court's order. As such, this court deems it fit to to direct the personal appearance of whom should I call? Of the director. Of the Director Secondary Education Assam on the next date. List this matter on 10th of June. The instruction is placed on record. This is not the way. 2 times she has written what he or she, I don't know, has written that it is 24. What? This is intentional, just to cover the time. And it was placed in the budget of 25-26. And the order was of 18. And it was directed to be completed within 6 months. Is this the way? Why are we sitting? Why are these courts functioning? I don't know. Okay, next matter. 40 and 41, yes.
Well, I'm paying for 4 weeks time because in compliance of various courts order, the government granted the SCP and MSCP
The
benefit.
counsel for the petitioner is not there.
No, my lord, she was waiting
Acha.
for her turn but left. My
On the
lord,
prayer made by Mr. A.K. Datta, learned counsel for respond number 4.
no, yes, my lord.
Respond number 4. List this matter again on
After 4 weeks, it is after objection, my lord, the matter was reviewed before the authority.
whatever it is 2020 contempt case, still that nothing has
My
been
lord,
done.
26 granted because many cases within the within India, my lord, several cases. My lord, they involve.
But then still, the counsel is not there. That is the problem. The
4 weeks, my lord.
the counsel for the none appears for the petitioner on call. Mr. A.K. Datta has prayed that he be given some time to
For review the matter, he presently review the matter. Objection.
get the updated instruction. List this matter again on 19th of June.
My lord, petitioner was present.
But then it's okay, not present when it is called. 42, Mr. Rahman.
Beg your lordship, my lord.
Hmm.
It is a very unfortunate affair, my lord. There is a content matter, my lord.
But unfortunate, okay, but that be the time.
I retired from service from the post of
Now, who is appearing for the contemners?
31st of July 2020, my lord. And in spite of the specific order, my lord, from the Honorable Gauhati High Court, that order has not been followed. In spite of, I have also submitted many representations, which are
Wait, the contemners are not represented. Service complete.
Service complete, my lord, only last date, my lord.
Hmm? All the 4 respondents.
My lord, all respondents as per the
Notice has been served upon the aforementioned respondents.
office.
3 and 4.
All respondents have received a copy as per.
But what about 1 and 2? 3 and 4, okay, but 1 and 2 is what happened.
All respondents have a copy of.
1 and 2 have retired. 3 and 4 are impleted or what?
3 and 4 have been implemented, my lord.
They are the new incumbents.
New, my lord.
So 3 and 4 will do.
As per the instruction they have received, as per the officer, my lord, they have received the copy, my lord.
3 and 4 has received.
Received the copy, my
But
lord.
Kamala Kanta Kolita, Bubul Lekharu, Benjamin Rongmai, Subodh,
From 2020, my lord, I have not received a pension amount.
Assam Khadi. Yes, but then they have to be here.
My lord.
Okay. Why don't you tell the Standing Council of Khadi and Village Industries Board to intimate?
My lord, my lord, my
Can you do it?
lord. Obviously, my lord.
Because officers go, new one comes, so perhaps
Your lordship may fix a date, my lord.
you inform the Standing Council of Khadi and Village Industries so that they can inform.
These officers are going about in vain now, not this officer.
Heard Mr. SSA Rahman, learned counsel for the petitioner. Although the office note reflects that service upon respondent number 3 and 4 are complete, but there were no representation on behalf of the said respondents. As such, Mr. Rahman is requested to inform the said respondents through the Standing Council of the said department.
My lord.
Please just-
After vacation, my lord, after vacation.
List this matter on 17th of July.
Highly obliged, ma'am. Obliged.
43, উঠিম আৰু 5টাত দেই।
It will
43 years.
Lordship, as per order of this honorable court dated 13/3/26, Lordship, the petitioner had approached the respondent authority, but till date, they have not asked for any documents or any.
Acha, whatever it is, I mean, what Mr. Ri?
That instruction also I do not have, my lord.
Huh.
But I have been told that, my lord, she appeared on 26th of March. But thereafter, what happened, I could not get it today, my lord. So, my lord, we fix it.
Okay, you bring the
Yes, yes, my lord.
complete instruction. Mr.
NJ Khatonier, my lord.
NJ
Khatonier, my lord.
NJ Khatunier, learned counsel for learned standing counsel for
Secondary education. my lord.
secondary education. Prays for some time to get the updated instructions. Prayer is allowed. List this matter on
Next week, Lordship.
next week.
Next week, my lord, thereafter, my lord. After that.
List this matter on 19th of June.
Yes, my lord.
It's almost 5. Yes, 44. Last time also due to paucity of time.
Yeah.
Yes. Get the decision taken on proposal submitted for provincialization. Acha, you have placed some.
Well, here, my lord, this is pending.
With reference and
we have
directed,
forwarded to the
the department has endorsed the proposal of the proposal director elementary and finance department for that. The department shall be more consequence and bring the matter to. Okay, Mr. PN.
PK Bora, my lord.
PK Bora, learned standing counsel for elementary,
Ma-
no,
We have put the-
higher education. The standing council for
Elementary education. my lord.
elementary education has placed an instruction by which it is intimated that the Department of School Education had endorsed the proposal of the Director of Elementary Education to the Finance Department for their concurrence. And it is further stated that once the concurrence is received, the department will carry on the next consequential steps. As such, he has prayed for some time. Prayer is allowed. List this matter after vacation or what?
my lord.
No.
My lord.
List this matter on 18th of June,
Obliged.
next to next Thursday.
My lord. Obliged.
Contempt case again. 46.
May it please your lordship. Lordship, in this case, what has happened is that the BTC had preferred a review against this order, and the review came to be dismissed on the 14th of May of last month. Thereafter, lordship, the same was communicated to the authorities, and similarly, steps have been taken towards compliance, your lordship.
Appointment of assistant professor, Lordship.
Appointment of
assistant professor.
assistant professor.
Though I have got highest mark, but lowest marks candidate has been given appointment because I am not included in BTR candidate.
Because you are not?
BTAD can, because I am not included in BTAD.
My God.
They say that though I got 67 marks, but BTAD candidate who got 58 marks, he will get appointment because it is within the Assam, it is within the not Assam. Therefore, court held that there cannot
Is
be,
this a reasonable classification?
no, there cannot be separate constitution for BTA.
Hmm.
So review is dismissed.
So what has happened here? I have the honor to state that as per speaking order issued from your end, the undersigned is directed to cause steps
Not with the last paragraph.
Prohibitions in it. After due procedure, what due procedure? Court has ordered you appoint.
Lordship,
Court has ordered in what way? Consideration.
no, Lordship. The court is directed to appoint the commissioner,
so-
Lordship. Accordingly, Lordship, the previous order is to be cancelled. So, Lordship, we are taking steps within 2
But
weeks.
this word you see, after due procedure, this is not contemplated. Further, the undersigned has been instructed by letter number under reference to take necessary steps in compliance with so and so forth for me. Okay. The learned counsel appearing for the BTC has placed an instruction by which it is stated that the previous orders were cancelled and and the Director of Education, Boroland Territorial Council has directed the Additional Principal Secretary, Boroland Territorial Council, Kokrajhar, to accord necessary approval for appointment in respect of the petitioner in compliance of the High Court's order dated 38. In view of the said instruction, Mr.
N.R. Sharma, Lordship.
N.R. Sharma, Learned Counsel for BTC, submits that some time may be granted for the updated instructions. Prayer is allowed. List this matter on when? Tell me a date.
Needed after 2 weeks, Your Lordship.
Before vacation.
On 19th of June.
Bless.
In this case, I need some time. Here we have
Okay.
preferred and review.
Now too, I will give time to everyone. Yes,
Here we have preferred an appeal that is also dismissed.
dismissed. Contempt case.
Contempt.
So, okay. 25 contempt case. When it was the order passed?
Order passed from
24.
20
Okay, Mr. P.K. Bora, Learned Standing Counsel for
elementary education.
Elementary Education, praised for a short accommodation to get the updated instructions. With regard to compliance of the High Court's order, prayer is allowed. List this matter on,
After vacation, can it be?
list this matter on 17th of June. Oh, July.
My lord.
Will it be too late?
What's up?
What you bring that decision? No time after July. Yes.
Item 48 and 49.
Yes, Mr. PJ Fukon. You should be this side, I think.
My lord, I have filed an
Oh,
IA
IA. Okay.
for some clarification on the earlier orders.
Not today.
Sure.
Okay. As prayed for by the learned counsels for the parties, list this matter when. If it is urgent, I'll take it up next week.
But,
List this matter on.
2 weeks, my lord.
There are no dates actually. I've already given dates.
After 2 weeks, my lord.
After 2 weeks means I don't want to keep it to the last week. List this matter on 23rd of June. Hmm. Down you. Looks painful. Yes, other matters, please. The court master will give you time. Okay. What about hearing? Item 53? Huh? This is 2023 matter.
Yes, Lordship, and earlier, 21/5/2026, and it was the hit from delivery of orders, Lordship.
Acha, then?
And today is unconsidered the hearing, Lordship.
So delivery of order by some other coordinate bench.
Yes, Lordship, court number 23, E20, 23.
So let it be listed before appropriate bench.
Yes,
Right. Learned counsel for 52 likha, learned counsel for the petitioner submits that the matter was heard by a coordinate bench and it was reserved for delivery of the order.
orders.
As such has prayed that the matter may be taken up by the same court. Prayer is allowed, listed before the appropriate bench. What 23 is, who's the judge? Huh? Within Justice R. Mojumdar,
Yes.
right?
Yes, Lordship.
Miss Bhattacharya, yes, you are waiting for some matter. 52. 51, okay, 51, 52 together. Some other day. What is that?
No, I'm for the department of
Okay.
Social Justice.
Social justice,
May come up after vacation only, so that
Is
we
it?
can get our instructions in the meeting.
as prayed for by the learned counsels for all the parties, list this matter on 16th of July. 16th of July? Yes, Mr. Fokam.
Lord, it was fixed on 23rd. Milord, without Milord fixing the date, Milord, possibly I'll be out of station on that week.
Okay, listed after 2 weeks.
2 weeks, that will be better.
Wait a matter, wait. Item 48. Huh? Listed
48 and
after 2
49.
weeks.